హలో. హెడ్ హెడ్ ఫోన్ వస్తుందా? హెడ్ ఫోన్ పెట్టు. ఎక్కడుంది? ఎందుకంటే 20 సంవత్సరాలు కూడా లేవు, నువ్వు ఇట్లా పాట వింటావు. ఎట్లా పాట వినాలే?
ఎవరు పాడు
లైవ్ ఉందే.
లైవ్ ఓన్లీ ప్రైవేట్ ఉంటా, అన్లిస్టెడ్ లో పెట్టమని.
ఉం?
అన్లిస్టెడ్ లో పెట్టమని చెప్పి పబ్లిక్ చేయని చెప్పి.
ఎందుకు?
కొంతమంది ఏమన్నా కాంట్రవర్షియల్ గా మాట్లాడితే లైక్
హలో. హలో. ఇది రావట్లే.
లైవ్ కొట్టండి సార్, లైవ్ అని కొట్టండి కింద. ఇంకా బాగా
హలో హలో, ఒకసారి జాయిన్ అయ్యి చూడు.
అది రావట్లేదు కదా.
ఏది? అది ఇదే. అది ఇక్కడుంది. ఉం. ఎందుకు? నీకు అక్కడ కావాలా? ఇస్తా. ఒకసారి చూడు. కాపీ వీడియో లింక్. రిత్విక్ కదా? రిత్విక్ స్పెల్లింగ్ చెప్పు. దీంట్లో ఉండదా ఈ అకౌంట్ వేరు? పిఐకే రిత్విక్ అట్ సిహెచ్ఆ ఆర్ఐ ఆర్ఐటిహెచ్ ఉండండి. ఆర్ఐ టిహెచ్
హలో
విఐకే కరెక్టేనా? నల్సార్ అట్ ద రేటా?
హలో చెక్ చెక్ హలో 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 హలో.
ఇక్కడిది కెమెరా అడిగియాలంటాడు. ఈ కెమెరా అది ఆ? ఏం రావట్లేదు. కెమెరా అతను ఆడుకోవాలి.
మీరు అక్కడి నుంచి స్ట్రీమింగ్ చేస్తున్నారా? రాదు అక్కడి నుంచి.
కంట్రోల్ ఇస్తారులే.
రాదు, ఇక్కడి నుంచి చేయాలి మీరు స్ట్రీమింగ్.
స్ట్రీమింగ్ ఎక్కడి నుండి చేస్తారు, కంట్రోల్ అక్కడి నుండి ఇస్తారు. కంట్రోల్ ఇచ్చేసి అదే ఏదో చేసినాం. ఉందా మరి? చెక్ చేసుకో. మంచి పని. అదే ఒక మాట చెప్పాలా, దట్స్ ద బెస్ట్ వే. దట్స్ ద బెస్ట్ వే టు డూ.
Hello, hello. Check. Final check. Hello, hello. Hello. Check. What? Hello, hello. I have no idea. Leave it at the OC pavilion. There. Yeah. Hello, hello. Check. Hello, hello. Check. Hello, hello. Check. Hello, hello. Hello, hello. Hello, hello. Check. Hello, hello. Hello, 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 hello. Hello, 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 hello. 1 sec. Yeah, note it down, na? Hello, hello. Check. Hello, 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 hello. Better కదా కొంచెం. Which one? The YouTube? That will come with slight delay. Hello, hello. Check. Hello, hello. Check. ఇంకా వర్స్ వస్తుంది. Hello, hello. Check. బెటర్ కదా. Hello, 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 hello. Hello, hello, hello. ఏం రాట్లేదు. Hello, 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 hello.
Hello, hello.
Oh. Did you press on something, Mustafa? Did you press something on WebEx? ఏ వస్తుంది ఇప్పుడు. హలో ఏం చేశారు. हेलो सॉरी. ठीक है कुछ प्रॉब्लम नहीं. हाँ फोकस ऑन गो टू प्रीसेट 2 ना. हाँ ठीक है. क्या है? आ रहा है ना. हेलो हेलो. हाँ आई कैन सी इट हियर आल्सो. इट्स फाइन. गो टू प्रीसेट 8 once. 8. ठीक है. What is 1? Is my voice coming out from somewhere else? अच्छा switch your speakers off ना. బాగా వస్తుంది. ఇట్లా వస్తే అప్పుడప్పుడు ఇట్లా క్విక్ 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 అంటుంటాను. ఎవ్రీ ప్యానల్ అయిపోయిన తర్వాత పైకి కింద. ఇప్పుడు బాగా వస్తుంది. ఇప్పుడు ప్రాబ్లం లేదు. దిస్ ఇస్ 3 నా. 4. अच्छा what is 3? अच्छा okay okay 5. अच्छा lift it up ना. Lift it up. Press on the up arrow. up हाँ बस ठीक है. and click on set there. Next to call there'll be set. Click on set. Done. So what is 6? How do, where is my voice coming out of? Acha cool. 7. Is my uh Ajinkya, is my phone on? It's coming from there, my voice. Acha, just it's okay. What is 7? Check, did you check the mics? Are they working properly? Gosh, why are these- Hello, hello. Check. Yashwant, Katish now. Better.
This one will be here. This one will be. So I
Yeah.
can't do anything from here.
You can't enter from. I will control the camera from there. You don't have to do anything. Once the panel is done, don't switch it off.
Sorry, I thought it was. Can you teach me also?
Hello, 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 hello. So to switch it off, the whole thing takes a lot of seconds. So don't switch anything off. Everything's supposed to be on. If they're facing difficulties, this needs to be done. Right? This is the primary, this is the backup. That's on here. Right? So if both of them are switched on, neither of them are going to switch on. Right? So both of them needs to be switched on. Both of them can't be switched on. All you need to do is when the gas is coming. See, you can hear me from there, right? That's good. Just adjust the height up and down.
It's just a
If it's not audible, adjust the mic up and down, but at no point should this fall. It's clipped onto this. Yeah, it's clipped onto this. Okay, it's pretty good, but that. So these two are off. Yeah. I gave it to some. This is that's so that's they're coming apparently. So that's it. Hello, hello, check. Sorry, so keep this switch on. Long press switches on. One press switches on. Long press switches on. Yeah. When something is not working,
Right. We'll just start with the session. And I understand there are many activities happening. So I thank everybody for joining us for this inaugural session. Just a few words on the background to the program. Before we started this program in 2019, the discussion was that while there's a fair amount of legal journalism that happens around what is happening inside the courtroom, and obviously practicing lawyers and judges are involved in adjudication on a full-time basis, we don't really have independent commentary on what is happening with doctrinal developments every year that is also accessible to the educational institutions. So with that goal in mind, our good friend Vikram Raghavan, who's currently a senior counsel in the World Bank, was visiting Nalsar and gave us this idea that why don't you collaborate with other stakeholders and plan an annual program where we can have an honest and independent discussion on the major doctrinal developments of the previous year. So that's how this program was born. We did the first one in January 2019, a second one in January 2020. Then with the pandemic, it was of course not a smart idea to have a physical conference. And last year, of course, we ended up doing it in April 22 on account of the Omicron wave. And this year, we are back to a regular format. So I would personally be grateful and thankful to Justice Ravindra Bhatt, who agreed to attend this inaugural session. And I know that he is very accessible to students and has always been very keen in matters connected to legal education. So we are grateful to Justice Ravindra Bhatt for joining us this morning. And our Chancellor, Justice Ujjal Bhoyan, was also very keen to attend. So I'm very grateful that as sitting judges who have very busy schedules, they could take some time off and spend this inaugural session with us. So may I request our Vice Chancellor, Professor Krishna Dev Rao, to just give a symbolic token of appreciation to the justices. Sorry. So Professor Krishna Dev Rao just wanted to hand over a couple of bouquets as a token of appreciation. Right. So before we start with the proceedings, just a quick word on the format of the conference. As most of you have seen in the schedule, we have 6 substantive sessions planned. We will, of course, get into the first panel after this inaugural session. Then there are subsequent discussions in the afternoon, one on populism in South Asia, another one on affirmative action law. Tomorrow, we have panels on gender jurisprudence, criminal law, and the last one being on technology and human rights. And the closing session will be by Professor Kalpana Kannabiran on her recently translated book from a work produced by the late KG Kannabiran. So without any further ado, I would request Professor Krishna Dev Rao to offer his welcoming remarks.
I welcome Honorable Justice Ravindra Bhatt, Judge Supreme Court of India, and Chief Guest of today's inaugural session of the Conference on Courts and Constitution. I also welcome our beloved Chancellor, Honorable Justice Ujjal Buyan, Chief Justice, High Court of Telangana, Professor Sitaram Kakarala, Professor Kamala Shankaran, my colleagues Vidyulata Reddy, Siddharth Chauhan, Arvind, Shravani and Anushri, the Law and Other Things LAOT team, and all other present here today. We have been organizing this prestigious conference for the past 3 years, and this year is the 4th edition, which gives us an opportunity to understand and analyze the constitutional journey last 1 to 2 years. This flagship conference represents the collective thinking and efforts of Nalsar, Azim Premji University, and Law and Other Things LAOT blog. I appreciate our student team that has been managing this Law and Other Things blog since 2017. Many constitutional law actors and scholars like Vivek Reddy, Vikram Raghavan, Siddharth Chauhan, Arvind, and many of these, the team of the students have worked together to make this a successful annual event. This conference truly represents Annual Constitutional Academy at Nalsar, which facilitates diversity of views and opinions. As a knowledge institution, our aim and purpose is always to develop intellectual curiosity and promote the dialogue between the constitutional interpreters, actors, scholars, and lay down the pathways for epistemic foundational thinking. An eminent constitutional law scholar, Professor Isha Shivji, memorably observed that Constitution is a legal, political, and ideological document, and he says it's a power map. It's perhaps true. My study and research on criminal justice clearly points out the deeper structures of power that exist within the criminal justice system. This power structure developed agonizing domain of pain landscape within the criminal justice system. The concept and principle of constitutionalism essentially emerged to deal with the power map and balance the power and tilt the scales of justice towards the poorest of the poor. In a rule of law society, the courts as protectors and guarantors of rights to serve justice. This gives legitimacy and enhances public faith. We do hope this year's seminar will compare and contrast the constitutional vision and its practice and contributes to constitutional scholarship. Thank you.
Thank you, Professor Rao, for supporting the students and supporting this initiative with full enthusiasm. And since our institutional partnership with Azim Premji, at least for this conference, is clearly contemplated till 2026, at least for the next few years, we will hold this program with the similar structure, but then we will try to improve it with time. So I now request Professor Sitaram Kakarala, who has been our collaborator for this program in the previous 3 editions, and once again has kindly joined us with his colleagues and students from the Azim Premji University to support this program. So sir, if you would like to just say a few words to the gathering.
Thanks, Siddharth. Honorable Chief Guest, Honorable Chancellor and the Vice Chancellor, colleagues from Nalsar, NLS, Azim Premji University and other institutions, and student friends. My role is ornamental. I think Siddharth every time inserts me to say a few words, but I think it's a privilege to be here, and it's a collaboration that all of us cherished from Azim Premji University, because the university has a deep interest in understanding both constitutionalism, constitutional values, and the institutions that keep this constitutionalism a robust sort of a process in this country. So in that sense, it's a kind of a converging, if you would like to call it a philosophy or an ideology, which brought us here. I'm particularly, of course, missing the presence of my colleague Arun, a former colleague Sudhir Krishnaswamy, who both are now in the National Law School, because they were very much part of the earlier version of the editions of this particular conference. I don't need to say too much on the significance of understanding institutions, a lot more than what we have done so far in India in the last 70, 75 years. It's an important moment in the beginning of 21st century that we see all over the globe. The apex judicial institutions are clearly undergoing something very significant transformation. And I think it is time that we pay not only to read and understand the case law, but also the larger processes through which constitutionalism is operating. I think national law schools and in general, all the law teaching has to pick up on that. And I think it is that spirit that brings Azim Premji University into the collaboration. So I'm very, very happy to be here, a privilege to be here. And me and my students and my colleagues here would be immensely benefited. And we are looking forward to today and tomorrow for this very enriching conversation. Thank you.
As most of you know, the main stakeholder actually who came up with the program was Vikram, but the student blog, which is now the Law and Other Things blog, actually has an older version. It was started in 2005 by Vikram Raghavan, Arun Thiruvengendam, and several others. But in 2017, they consciously decided to set up a student team at Nalsar. And for the last 6 years, the student team, I personally feel, has been doing an excellent job of attracting written submissions, curating them, and also giving a platform for younger people to write. So it's one of the few blogs where even undergraduate or postgraduate students are writing, and they're getting good feedback and mentoring from the editors of the blog. So every year we have been reconstituting the student team. This year the onus has lied on 2 fifth-year students, Shravani, Anushri. I hope next year there'll be a couple of others, and we'll keep the cycle going. But since it is also their event primarily, I would request them to just give us a short summary of how the blog has developed in the last 1 or 2 years. Please come.
Good morning, everyone. Thank you for joining us today. I'm Anushri. This is Shravani. Both of us are 5th years at Nalsar. We have been associated with the blog since the beginning of our law school journey. And the blog, as Siddharth has already mentioned, the blog started in 2005. It finally shifted to Nalsar in 2017. It has been under the leadership of our seniors, including Lavish and Parika in 2018, Aishwarya and Priyamvada in 2019, Vishal and Dayar in 2020. We took over from Bhavisha and Gayatri last year in 2021. Sorry, 2022. This year, we tried to move a little bit beyond what LAOT was conservatively doing. We started a series of podcasts last year, thanks to both Bhavisha and Gayatri. It started with an interview with Arvind sir, who is right here. You're the first person we interviewed. We started a podcast on the Indian Feminist Project, which was started by Aparna ma'am, who's a senior editor with us. Following that, Vikram had this lovely idea of collaborating. Vikram and Malvika both had this lovely idea of collaborating with Seed. Shravani is going to take over from there.
Yeah. So, hi everyone. I'll just give you a brief of how LAOT works. Primarily, there's a two peer review process that takes place. So firstly, it's the student editors who review submissions. And once the submissions pass our review, it goes to our senior editorial board. It consists of Anurag Bhaskar, Aparna Chandra, Bhavisha Sharma, Dayar Singla, Disha Wadekar, Malvika Prasad, who is with us here today, Mohsin Alambat, Nick Robinson, Nikita Sonavane, Raisa Vakil, Vikram Raghavan, Vishal Rakhicha, and Venkat Venkatesan. Other than what Anushree mentioned, other than the podcasts, we also have a new scholarship section that you can check out on our blog, where we host roundtable conferences on emerging public law scholarship. And we also host the Courts and the Constitution conference. Apart from this, we have come up with 2 new collaborations. One is with SEED, which is the community for the eradication of discrimination in education and employment. So we have candidates who were selected by SEED who are being mentored by our senior editorial team to produce descriptive as well as analytical pieces that will make legal analysis of contemporary issues. Apart from SEED, we are also coming up with a collaboration with CPAP. Anushree?
The CPAP collaboration is still in process. We started it with Nikita Sonavane, who's a senior editor with us. The idea is the same format we are following with SEED, to take people from their organization and mentor them with the legal writing and critical writing and legal writing on the blog.
That's it. Thank you so
Thank
much.
you.
for
Thank
coming
you
to
so
the
much for being here.
conference.
I would now request our Chancellor, Chief Justice Ujjal Bhuyan, to offer a few remarks. Justice Bhuyan has been visiting the campus regularly. Some of you would recall he visited us for the inauguration of the Jeevan Reddy chair, and most recently, of course, the grand convocation that we had a few days ago. So over to you, sir.
Honorable Justice S. Ravindra Bhatt, Judge, Supreme Court of India, Professor Sri Krishna Dev Rao, Vice Chancellor of Nalsar, Professor Kakarala, Azim Premji University, Professor Vidyulata Reddy, Registrar Nalsar, distinguished speakers and faculty members, and my dear students. It is true, I have been visiting your university quite frequently of late. But not only this university, whenever I get an invitation from any college or university, I readily accept for primarily for 2 reasons. When you are with students, you don't feel that you are aging. You feel that you are one amongst these students. Secondly, and that is more important, students, or in particular, or youths in general, they do not have the prejudices or the bias which is outside the campus. Their minds are fresh. Their minds are free from all these viruses. And therefore, they are vibrant with new ideas. So this vibrancy is infectious. So therefore, whenever I get an opportunity, I readily accept. And so therefore, I am here before you. I must thank Justice Ravindra Bhatt. Despite his busy schedule, he has readily agreed to be part of the inaugural function. Thank you, sir, on behalf of the university. This conclave of courts and constitution, I have been told, it was started in 2018. And because of the pandemic, it got disrupted in between. It is really a very innovative process, must be carried forward. In fact, today morning I woke up early and I was thinking in my chamber what to speak to the young students. Whenever I go, I ask the students of all the articles, since we are in the debating the courts and the constitution, I always ask which article or what is the essence of the constitution. If in one phrase, in one word, or in one sentence, if you are to describe the essence of the constitution, how will you describe it? Or which article you find reflects the essence of the constitution? Some say article 21, some say 19, free speech, this, that. According to me, the essence of the Indian constitution, if you go through the debates of the Constituent Assembly, it's equality between men and men, equality between men and women. Article 14. That is the essence of the Indian constitution. Some may say that affirmative action which is there in 1516, does it not violate Article 14? I was just trying to find out, locate a judgment. Please go through that judgment of Justice Chandrachud. This is regarding this medical admission, NEET, I think from Chennai. Neil versus Union of India. Please go through it. It's a jurisprudential exposition of the concept of affirmative action for historically this oppressed identities. So this is one area which I thought I should speak. I was wondering which are the judgments during this period which can be said to be landmark judgments. One judgment certainly is the judgment of, in the case of Vikas Kumar versus Union Public Service Commission, where the Supreme Court explained the principle of reasonable accommodation in the context of disability rights. Of course, when we talk of reasonable accommodation, this principle can be extended also when we talk about gender rights or when we talk about rights of transgenders. The other case, which has caught the attention of the nation and also of the younger people, is the decision of the Supreme Court in X versus Principal Secretary. While I was in the Bombay High Court, our bench had delivered certain judgments regarding reproductive rights, a right of a woman to have bodily autonomy, to have this final say whether she would go for an abortion or not an abortion in the context of this Medical Termination of Pregnancy Act. Now, finally, in this judgment, Supreme Court has upheld that right. Not only that right, Supreme Court has also expounded on that and had spoken about right, not only right to safe abortion, but Supreme Court has developed on the right, this right to reproductive rights as the right to dignity. In the Bombay judgment, we examine this right from the perspective of mental health. And we have said that mental health state of a person is a continuum, with good mental health being at one end and diagnosable mental illness at the opposite end. Therefore, mental health and mental illness, although sound similar, are not the same thing. You'll find that mental illness is a defined expression under the Act, but not mental health. If continuation of the pregnancy causes grave danger to the physical and mental health of the woman, then notwithstanding the legal embargo, in our view, the aggrieved woman would have a right to seek safe abortion. The other judgment, there's a recent judgment on the election of, or the selection of election commissioners, very recent judgment. This is a very important judgment. Of course, there are critics. Argyas and Gupta says that we need to wait and watch how this judgment works out. But certainly, it is premised on the principle of right to information, which is derivable not only from Article 19(1)(a), but also Article 21. So this is again an important judgment we should keep in mind. The last of the judgments which I thought also important is the minority judgment in Janhit Abhiyan, where the majority upheld 10% reservation for economically weaker sections. But it is often said that the majority may lay down the law. The force of law may be with the majority, but wisdom lies with the minority. This we have seen from, as student of constitutional law. You must have seen it. You must have read it. In A.K. Gopalan, the view taken was 1951. The view taken was that two views were taken, that Articles 14, 19, 21, they were separate, can't be read together. And the second view was that as long as there is a procedure in place, a person can be deprived of his life and liberty. In R.C. Cooper, 20 years later, that judgment came. These articles are not islands. They're all intertwined. When we read or examine 14, we have to fall back upon 19. We have to read in the context of 21. Finally, in Menka Gandhi, the ghost of A.K. Gopalan was finally buried. They said that law has not only to be not only formal, but it has to be fair. Principles of natural justice were read into in the fair procedure. Therefore, this is how the minority view taken in A.K. Gopalan by Justice Fazal Ali, he was minority, a single judge, that has found resonance with the majority 20 years later, 25 years later. So, as a sitting judge, I have my limitations. I will not comment on the economic, this Janhit judgment. This is in the public domain. It has generated a lot of debate, and rightly so, it should be. Judgments are read, should be read, discussed, critiqued. That culture should be developed. And I'm sure the judgment, I don't know, the Janhit Abhiyan judgment, perhaps I do not know what holds store for tomorrow. May not, the last word may not have been spoken as yet. So, friends, you are young minds, you are inquisitive minds. Each one of you should question. This is what our Chief Justice of India also says. You must have that spirit of question. Nothing should be taken for granted. Everything must be questioned. And that is the spirit of law. I congratulate the organizers for organizing this conclave. It should continue every year and go from strength to strength. Thank you very much.
So I thank Chief Justice Bhuyan for supporting us in this program, and it's very reassuring to hear that we have support to carry on the program into the future. In fact, since Justice Bhuyan mentioned the importance of dissenting judgments, I'm sure most of you would have come across a recently edited volume produced by the retired Justice Rohinton Nariman, where he has put together his study of several dissenting judgments, not just from within India, but other parts of the common law world. And that would be a good reference material for you as well in the next few years. So now we invite Justice Ravindra Bhatt to perhaps speak to the students and offer his reflections on his engagement with the judiciary.
Chief Justice and Chancellor of Nalsar, Justice Ujjwal Bhuyan, Vice Chancellor Krishna Dev Rao, Professor Vidyutala Reddy, Vidyulata Reddy, Dr. Sitaram Karkala, all distinguished panelists, faculty members, researchers, students, ladies and gentlemen. I'm delighted to be here amongst you for the opening of the 4th edition of the Courts and the Constitution in 2022 in review. I am happy to note the participation of distinguished speakers and academics in the 6 sessions so carefully thought out. I'm also touched by the fact that one of the sessions is in memory of an outstanding academic, Shamnath Bashir, whose legend will endure, though his candle burnt out too early. It gives me great pleasure to be here discussing an area of law which is close to my heart and, as you have shown, is to yours as well, the Constitution of India. In my mind, the hallmark of a great democracy, especially a young country like ours, which has the unique distinction of being multifaceted, is this Constitution. This comes with its own set of challenges regarding the interpretation of this document, with different interest groups praying for different outcomes in courts of law. The onus then is on the judges to carry out their duty in upholding the values of the Constitution. That becomes significant. Keeping with the theme of the conference, today I will briefly be discussing an overarching issue, the interpretation of this brilliant text, which is the culmination of efforts of some of the wisest men and women who have graced Indian politics and who were truly nation builders, successfully fulfilling a daunting mandate of mapping out a vision for the future of India. In doing so, my endeavor will be to convey that while the dynamic nature of the Constitution ensures its reputation as a living and breathing document, there are some core essentials which are intrinsic to its identity and which remain and will continue to remain unchanged in the years to come. Attempts are made often by scholars and theorists to draw analogies between the interpretation in constitutional or jurisprudence of the United States to that of our country. Are we textual originalists, proponents of living constitutionalism, evolutionists, Balkan's hybrid living originalism, or some other ism? This is, in my opinion, a reductive process and has its own limitations. Unlike the polarizing divide within the US Supreme Court in political leanings, ideology, and as a result of interpretation approaches and tools employed by judges, India, much like its social fabric, has had a richly diverse pool of judges who are products of their times and unique circumstances. Their individual voices may be many, but when they speak as a court, it is endeavored to be in unison, with departures only when thought necessary. The guiding focus is on locating a value in the Constitution and giving effect to it within that framework in terms of evolving necessities. That is why it's far more difficult to pigeonhole or generalize patterns in decisions of the Indian Supreme Court over the last 7 decades. Broadly, some shifts are apparent. For instance, in the early years, the court was hesitant to intervene in what it termed as the political thicket. So in the state of Rajasthan in 1977, when approached by 6 plaintiff states seeking a declaration that the letter of the Home Minister recommending to the governor to dismiss state legislatures was illegal and seeking an injunction against the union from resorting to Article 256, the court held that Article 356 calls for an assessment of a situation. Insofar as that provision embraced matters of political and executive policy and expediency, the court held that it could not interfere with these unless and until it is shown that the president was going to contravene some provision of the Constitution. This restrictive interpretation was drastically different from the court's decision 17 years later in Bombay. The court, in a 9-judge bench decision considered in 1994, the circumstances in not 1 but 6 states where elected governments had been dismissed by the union's exercise of power under Article 356. These were just a few in a line of many such cases of use or abuse, as you may term it, by the union invoking the president's rule in states that were governed by a party other than the ruling party. Of course, the court had the benefit of an important amendment, yet the intervening developments in constitutional and public law, including the decision in Kehar Singh, led the court to hold that there were no constitutional off-limits. Without impeding the separation of powers doctrine, but to breathe life into the framework of checks and balances envisioned in the Constitution, the scope of judicial review was carefully delineated to check malified exercise of power. Recognizing that Article 356 was justified only when there was a breakdown of constitutional machinery and not administrative machinery, the court also held certain and laid out certain principles that were indicative of when it would be proper or improper to impose president's rule. As I'm sure each of you can tell, this was by no means a popular decision amongst the political class. It had profound implications on center-state relations, but it was what the court saw as necessary and a constitutional check for placing limitations on the arbitrary dismissal of elected governments. The power of judicial review at its core is a manifestation of the separation of powers doctrine. The scope of this power has been the site of hot political contestation spanning the decades since India's independence. One would be amiss to even bring up judicial review without referring Keshwananda Bharati. By a slim majority, but yet a majority nevertheless, the court held that there were certain essential features of the constitution which could not be, there were certain essential features which could not be amended. These included several articles and several values which were laid down in the different judgments, such as equality, federalism, secularism, separation of powers, and so on and so forth. For something to be an essential feature, it had to be part of the constitutional law binding the legislature. In other words, it must limit the amending power of the parliament. This forms the constitutional identity, the impact on which the proposed amendment is tested. The fact that the Constitution survives without loss of its identity and endures despite alteration is a direct result of the introduction of this doctrine into our constitutional law jurisprudence. There has been time and again debate on the efficacy of this principle, but I would only point to one thing, that of the 58 challenges which were made to constitutional amendments before the Supreme Court, only 7 or 8, I think, succeeded. This doctrine has aided the court in thwarting excessive action to amend the constitution. The instances are Indira Gandhi, Minerva Mills, and it has also importantly allowed Parliament to guide innovation in policy and take marked departures from the past. However, it is not suspended in a vacuum. While the judiciary is aware that Parliament has wide scope for lawmaking, it often looks backwards to conduct substantive basic structure review and isolate the essential feature which is intended to be protected. Justice Chandrachud Senior eloquently opined that such questions have a historical slant and content, and history can furnish a safe and certain clue to their answer. The court's decision in R.C. Podwal is another great example of this. In this manner, the court has, when faced with gaps in the constitutional framework, or a situation that undermines its expansive and carefully designed structure, sought to plug these gaps by relying on values contained within the Constitution itself and molding it to the necessities of the times. Sometimes the clues are the text, and sometimes the court must look beyond it to identify the values that are ingrained in the Constitution and run through its pages. My favorite example is the term separation of powers. If you all run a quick Control+F on the Constitution soft copy, you will all keep handy. You'll find that this is mentioned in a grand total of 0 times in the Constitution. But can there be any doubt that it's one of the overarching themes? All one has to do is to read Articles 50, 245, and 246 with the 3 lists in the 7th schedule to the Constitution for the answer, and the chapter on the judiciary. These core values are unchanging, although the conceptions of it may be novel. This is an overview of how constitutional amendments are scrutinized. But this is true even while interpreting the Constitution or statutes against its backdrop. The court will isolate the constitutional core or the value, and through its judgment sound off the other organs and flag its importance. This has both guided and caused impact to both our country's constitutional and legislative histories, with, in turn, cascading effects at a macro level on the interactions between the organs of the state, and at a micro level on the individual and their rights. A fitting example in relation to the interplay between organs of the state was noticed in the issue relating to the selection of election commissioner, which the Chancellor briefly alluded to. I don't have to elaborate on this. Last week, the Constitution Bench of the Supreme Court, taking note of the historical context and expanding powers, function, and protection offered to the Election Commission presently, which is in itself a result of litigation before the courts, concluded that there was a discernible gap that required plugging in the absence of law. This gap fundamentally diluted the constitutional right to vote and conduct free and fair elections. Therefore, it was unanimously held that till such law was made in accordance with Article 324, the Chief Election Commissioner and the other commissioners would be selected and appointed appointed by a 3-member committee consisting of the Prime Minister, Leader of Opposition, and Chief Justice of India. What I want to draw all your attention to is that this is yet another example of the court where it looked backward, so to say, to the Constituent Assembly debates to discern the true intent of the provision, to test whether in the constitutional scheme with its checks and balances, whether they are functioning. It was recognized that the institution of the Election Commission was meant to be fiercely independent and outside the control of the executive government. However, the modalities of their appointment and administration that guarantee this could not be agreed upon, which is why it was left to Parliament to enact the law. Since Parliament had not enacted the law, the court made the declaration that it did. The Supreme Court for nearly 2 decades and a half, and again, I don't wish to repeat it, this is about the compartmentalized view of fundamental right, which the majority in Gopalan, which there are two aspects to Gopalan. One was a smaller issue, which is interpretation of the Constitution. Is it legitimate to look into the Constituent Assembly debates? A.K. Gopalan, in a very short 4 sentences, brushed aside the entire debate, saying a speech made in the course of the debate on a bill could at best be indicative of the subjective intent of the speaker, but it could not reflect the inarticulate mental processes lying behind the majority vote which carried the bill. This was the conventional British view. This understanding of constitutional interpretation missed an all-important aspect, which is that unlike bills and legislative proposals debated in the British Parliament, the Constituent Assembly sat for over 165 sittings, had several committees which deliberated numerous models of constitutions, visualizing ahead, as it were, and foreseeing the direction that this nascent republic would take. The members of the Assembly participated actively. There were 4 readings and many amendments to the Constitution, which also underwent several revisions and versions. Within 10 years, that is the decade of the 60s, this approach had changed. In AVS Narasimha Rao, which is a case connected with Andhra, which led to the amendment of the Constitution, the Supreme Court used the debates as an authentic extrinsic aid. The 11-judge bench decision in Privy Purse's case referred to the debates, especially in Article 291, and went so far as to say that the debates by the august body were relevant. The 9-judge decision in Dhillon did not decisively rule against the use of the debates, but very tellingly analyzed each relevant debate on the point on the residuary head of the union list and ruled in accord with it. The situation changed dramatically when in Keshwananda, a majority of judges held that the debates could be looked into not only to discern the history of a provision, but also the intent of the framers. The best enunciation of this can be found in Justice Matthew's opinion. So you see, within a period of 20-25 years, there's a change in the way you look at the same document. And that is mirrored by the other approach which the Chief Justice and Chancellor mentioned, the compartmentalized view which underwent a complete overhaul. And in bank nationalization, this is what the court said. It is necessary to bear in mind the enunciation of guarantee of fundamental rights which has taken different forms. The enunciation of rights either express or by implication does not follow a uniform pattern, but one thread runs through them. They seek to protect the rights of the individual or groups or of individuals against infringement of those rights within specific limits. Part 3 of the Constitution weaves a pattern of guarantees on the texture of basic human rights. Again, how did the court lead to this? It is not an overnight development. You had brilliant judgments. One is Kochunni, where again, after quoting the majority judgment, a small deviation, but an important deviation is made by Justice Subbarao. He says, personal liberty is more comprehensive a concept than has a much wider connotation than the right conferred under Article 19(1)(d). Articles 19(1)(d) and 22 deal with different subjects, whereas both Articles 19(1)(f) and 31 deal with the same subject. And then a lot of observations to the same effect, which is incrementally taken forward in Satwant Singh and Khadak Singh. In Khadak Singh, of course, it's a minority. The court displayed a broad and expansive view of Article 21, where it held that personal liberty is a compendious term, including all varieties of rights that go to make up the personal liberties of man, other than those dealt with in the several clauses of Article 19. In other words, while 19(1) deals with particular species or attributes of that freedom, personal liberty in Article 21 takes in and comprises the residue. Of course, that was a minority, but this seed the thought. In the 70s, the judgment in Gobind and later the judgment in Rajgopal had dealt with the question of whether the facet of personal liberty, such as privacy, is a fundamental right. From this discussion, what is discernible is that the court's role in interpreting the same language of liberties and rights and its approaches have greatly evolved with the times. But this evolving jurisprudence is not whimsical or random. It relies heavily on the rules of interpretation, background and history of the law, search for precedent to undermine legitimacy, and the attempt to harmonize with the needs of the times if the generalities of the law permit. The values of the Constitution remain unchanged and protected. But through constitutional interpretation in this manner, new dimensions of rights are recognized and conceptualized. And this is the enduring legacy of our Constitution. To borrow from Judge Learned Hand, it is because of the effects of the interpretive process the body of law in a representative democracy evolves. Its ends may be unknown, its beginnings obscure, its growth spontaneous and unpremeditated, yet it has an organic integrity. The whole of it has been fabricated in this way, like a coral reef of the symmetry of those whose eventual structure the artificers have no intimation as they labor. The Constitution's relationship with the individual is special and bears this out. It is a culmination of the ideals of liberty, equality, and freedom that we spent over 2 centuries wrestling from our colonial masters, and encapsulates the hopes and dreams and progressive vision for the future of Indian society as held by our founding fathers and mothers. While the text of Part 3 contains the most basic and non-negotiable aspects of freedom to be enjoyed by citizens, and some by people regardless of citizenship, the court's interpretation of the same over 7 decades has richly broadened its scope in order to bring to life its true meaning. The transformation in Part 3 was incredibly significant. What began as a reading of the articles in isolation was gradually rectified, and as our Chancellor, the Chief Justice mentioned, the ghost of this isolationism was laid to rest in Maneka Gandhi. The conjoint reading of the provisions was deemed necessary to instruct the court as to the true values of the Constitution and guide it appropriately when deciding the cases of personal liberty. Indeed, placing reliance on the text alone has the potential to produce contradictory results. One need to only look at the mistake that was Jabalpur, which sanctioned preventive detention, to be overturned years later in Puttaswamy on the strength of the same provisions. This is where a judge's understanding of the Constitution and what is required of them to truly bring to life its values plays a role. In the past 2 decades, we have witnessed a remarkable shift in our society's thinking. This is undoubtedly also reflected in the judgments of the courts, most pronounced in those pertaining to personal autonomy. In National Legal Services Authority, that is Nalsar, the court took cognizance of the plurality of genders for the first time and the need to protect those who identified with a gender different from their sex assigned at the birth. It emphasized the expansive definition of the right to freedom of expression, subject only to the restrictions placed under Article 19(2). This was a milestone decision furthering the dignity associated with an individual, elucidated in Francis Corelli Mullin and Anuj Garg. Again, barring the preamble in Articles 39 and 51A, the importance of ensuring dignity of an individual has been judicially evolved and expanded to include a growing list of requirements to achieve this goal. Puttaswamy, of course, was a game changer, but more significantly, it corrected the interpretation of the right to privacy under Article 21 as not being fundamental, as held in MP Sharma and Khadak Singh. This judgment was remarkable for its vision of what the Constitution could achieve and must strive towards. Forward-looking, the unanimous verdict has recognized in unequivocal terms the sanctity of the inviolable personal space associated with every individual and the right to protection against its arbitrary interference. Not only that, but the observations of the court placing reliance on American jurisprudence were significant in laying the groundwork for Navtej Singh Johar subsequently. To me, Navtej is a testament to the fact that rights enshrined under the Constitution are for everyone, even those constituting alleged minorities or outliers. No person can be deprived of its protective shield. Of course, some of these decisions are met with fierce opposition. The struggle between populism and constitutionalism is a serious roadblock. I understand that an entire panel discussion will illuminate the nuances of this debate further. Therefore, I will not delve too much into it, except to mention that the true mettle of a judge is tested in such cases. The ability to withstand tremendous pressure in order to do what is right, not what is popular, and that's easier, is gained with experience and an unwavering belief in what the Constitution stands for. This has aided me all these years to take comfort in the fact that as long as I stay true to the constitutional vision, I would have fulfilled my responsibilities to the best of my abilities. Evolving standards of constitutional morality have played a huge role in reviewing the law. 20 years ago, the idea of decriminalizing adultery seemed far-fetched. Criminal law is presumed to be gender agnostic, and yet Section 497 treated women as victims and confusingly absolved them of the crime. It took Joseph Shine to betray this patriarchal view. Similarly, the stigma attached to having an abortion, an inherently private decision which always merited the least interference, was strengthened pre-1971 due to the penal nature associated with the act. It took various avatars of the MTP Act from initially only being accessible to married women to now, in no unclear terms, ensuring access to safe abortions to all women, irrespective of marital status, as held in X versus Principal Secretary. To reinforce the point that controlling women's bodies could no longer be a societal objective, the autonomy exercisable over one's body was supreme, and unless absolutely merited, warranted no intervention. What is perhaps most evident from all that I have said today is that there is no straitjacket formula to constitutional interpretation. What is certain, however, is that in India, the endeavor is to reshape the same core liberties and rights by interpreting them contextually with the times by the courts, from a compartmentalized view of the fundamental rights to more recently giving them new dimensions that offer wider protection to the individual and their autonomy. The courts and the people repose faith in its framework and have come a long way. The opportunity for such expansive reading of the text is owed in no small part to the constitutional adjudicatory role of the courts. This includes the wide scope of jurisdiction and access to constitutional remedies that the document expressly bestows on the court and the people. This is not just to the Supreme Court, but importantly to the High Courts. In a very important decision often overlooked, Dwarkanath, again Justice Subbarao, said that Article 226 is couched in a comprehensive phraseology, and it ex facie confers wide power on the High Court to reach injustice wherever it is found. The Constitution designedly used a wide language in describing the nature of the power, the purposes of which and the person or authority against whom it is to be exercised. I just want to flag that there are two aspects to every court decision. One is the identification of the value within the Constitution. We call this the normative content. And second is the directions for its implementation. While isolating these values or core principles, the normative content, the courts are guided by the text, but not limited by it. They might need to look beyond it. This is because the Constitution is not an end in itself, but a tool which each generation revisits with its own aspirations for the future. Now, whether the body politic accepts it immediately or criticizes only to see later merit in these directions, whatever the outcome, there can be no question of legitimacy of the normative aspect. In other words, the level of acceptance it enjoys does not affect a court's declaration's legitimacy. The court's role in the national norm-making process often comes into sharp focus, but the reality remains that a large part of it is assimilated into the body of law. Regardless, this normative content is declaratory and carries with it the full weight of the Constitution. A reading of Article 141 and 144 makes this point, that all organs under the constitutional framework are enjoined to give effect to these declarations. In this manner, the Constitution works. There are checks and balances, of course. When a declaration is deemed too wide, Parliament intervenes. One of the most spectacular examples is the recent amendment to the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Amendment. But then the counterpoint which I wish to put to you is, now Article 17 says that untouchability is outlawed and is an offense. If Parliament were not to make a law, would that be a dead letter? I can with surety say that this would not be the case. It would have been incumbent upon the courts to step in to draw up principles till such law was enacted. Not to create offenses, but to say what is the way out, whether it is a civil law remedy or a constitutional law remedy. In this manner, the constitutional scheme checks itself constantly. But the efficacies of these checks and balances greatly relies on the people, vigilant citizens like all of you students gathered here today, that take these organs to task. I must congratulate the organizers, Nalsar, the Azim Premji universities, for putting together this event and providing a platform for scholars and students to interact and engage with the Constitution through these 6 diverse panels in the span of the next 2 days. I can only hope that the study and admiration of our formidable Constitution for each of you grows through your crucial engagement with its minute cogs and gears. Thank you.
We thank Justice Bhatt for giving us an overview of how the field is developing. And there are, of course, for students who are in the constitutional law course, you would have heard several points of resonance with what we are covering in the classroom. But we also need a culture of frankness about how the institutions have to be examined. There could, of course, be critiques from within the institution, but those of us outside the institution also have a certain responsibility to also think about the language and the long-term implications that we use to question the court's developments. So to close this session, I would request our registrar, Professor Vidyalata Reddy, to offer a formal vote of thanks.
So I thank the Honorable Justice Sri S. Ravindra Bhatt, Judge, Supreme Court of India, for coming all over here and for enlightening us on the far-reaching decisions of the Supreme Court in the last year. There are some decisions which were very important in our private life, like our abortion rights, etc. And there were certain far-reaching decisions which will have impact on public life, such as appointment of election commission members. so on and so forth. And sir has touched upon even the development of the law and the judicial review in relation to the power of the parliament to amend the law, and from due process from A.K. Gopalan to R.C. Cooper and subsequent decisions as well. But one interesting fact about R.C. Cooper is the judicial wisdom from the R.C. Cooper. One thing not necessarily with the judicial review, but on the factual side is that the major opposition, one of the reasons for opposing nationalization was that the public sector employees will not work with the same enthusiasm and commitment or with the fear in public sector, so it should not be nationalized. But today, if we see the public sector banks have flourished, are performing far, far ahead, and most of the private sector banks which prevailed then at that time are no more in existence. There were 1,000 private banks at that time. Today, we don't have. At least 600 of them are closed as on today. So so as a nation, in terms of patriotism or the Indian employer psyche of working with commitment in public sector, I think R.C. Cooper is a winning case for us to celebrate in that context as well. Besides, as judicial review, think that the constitutional law teacher might have debated extensively in the classrooms for that, and also from the judges. So thank you, sir. And we need to thank Justice Ravindra Bhatt, sir, not just for being here today, but has been a person who has been continuously supporting Nalsar for more than a decade now. I recall his presence here in 2012 when he was the judge of Delhi High Court, coming for a project on global internet governance advocacy project, which was the Government of India project at that time, where judiciary was contemplating about coming into information technology and introducing information technology into judiciary. So sir was pioneering at that time and started working. And since then, his association with that is continuing. And I remember subsequently also when electronic evidence rules were to be framed, Nalsar, Telangana High Court and Supreme Court had a joint committee discussions also. So sir has accepted a lot of Nalsar students as his clerks for judicial clerkship. Sir, we thank you very much for your continuous support for the institution, and we hope that this support will continue for our students' enrichment and enlightenment. Thank you, sir. And I now thank our Honorable Justice Ujjwal Bhuyan, Chief Justice of Telangana High Court, and our Chancellor. And as the Chancellor of the university, he has enlightened us on the importance of law review. There was a Supreme Court judges who constantly told us that judicial review can't be strengthened without universities tearing the judgments and making law review really a review which it should be like. And it is very warm and, very welcoming, or in a way very appreciative to hear from our Chancellor telling us that do the law review in a very proper format, which university should be doing, because university means universal knowledge should come, and we should debate in universal ideas should come, and we should discuss in that context. So thank you, sir, for reassuring us to do that. Law review is essential to ensure justice and for wise judicial review to happen. Thank you very much, sir. Thanks for your continuous support, and also assuring that you are more than, you will be more happy to visit our campus, or in a way your campus. So thank you, sir. Thank you very much. And I have to thank the resource persons who have really taken their time out, and who will be participating the next 2 days. We have advocates from Sri Lanka, we have advocates from Bangalore, Delhi, and Hyderabad. We have researchers and professors from all over India as well, and also from Bangladesh. We have NGOs from Bangladesh, and we have very, very eminent scholars and researchers and professors and advocates who will be coming here. And I wish that these next 2 days we will have a very enriching intellectual discourse in the constitutional affairs. Thank you for all the resource persons for taking their time out and coming and participating in this discussion. And I would like to thank our co-organizers, Aziz Premji University, for being a co-organizer along with us. And I thank the students team and my faculty colleague Siddharth Chauhan for taking up this initiative and supporting the students extensively. So the law and other things blog and the students who are doing the lot of running around to do this happen. I congratulate all of them and I wish you all the best and thank you all. And lastly, I thank my faculty, staff, support staff, press, media, and I'm sorry if I have forgotten anybody. Thank you.
So we have a tea arrangement outside. Professor Rao also wanted to take a small photograph with our guests. So maybe faculty colleagues and resource persons can just join us briefly for that photograph. And we do have a tea arrangement outside. We'll immediately try to start the next panel in 15 minutes from now.
Hello.
Hello, can you hear me?
Yeah, Alok, we can hear you. Can you hear us?
Yes, I can hear you. Can you see me?
Yes, yes, we can.
Okay. Connection is coming through clearly. You can make out what I'm saying.
Yes, we can.
Okay, perfect. I'll keep my video off until you tell me it's ready to start.
All right, all right. Thank you.
No worries.
Okay, Alok, there was a bit of a delay with the inaugural session. We wrapped it up. So we'll try and
No problem.
Right, we'll just start the panel in a couple of minutes.
Sure thing. I'm here. I'm ready. Let me know whenever.
Right, you're okay with going third, right?
Yeah. That's perfectly fine.
Sure. Right.
Hi, Vakasha, Apurva.
Yeah. They'll have to come closer to the mic. So you'll hear them once.
Oh, okay.
Yeah.
Sure.
Their table mics are not working. So
Oh, okay.
right. Yeah. That's fine. We'll call them one by one. Yeah.
Sure.
Okay, welcome to the first substantive panel for this program. We did run into a bit of a delay with the inaugural session, but we did have Justice Ravindra Bhatt and Chief Justice Ujjwal Bhoyan joining us. And obviously, it was important to also acknowledge the participation of different stakeholders who've made this program possible. So without further ado, initially, this panel was supposed to be moderated by my colleague, Mr. Neeraj Grover, who's with the Azim Premji University. But because of some family obligations, he couldn't come physically this time. So I'm substituting for him. But the three substantive speakers that we have for this panel, as you would have seen in this program, include Ms. Apurva Vishwanath, who's now with the Indian Express, but has been doing some great work in legal journalism. And many of you would have been following the reportage that she's doing on judicial appointments. And it's amongst the most informed and most analytical coverage on that area that we can find these days. Our second speaker is Vakasha Sachdev, who's currently with the fact-checking website Logically, but earlier had also worked in legal journalism for a substantial period of time. And in that sense, both the speakers have considerable experience in commenting upon the court as journalists. And obviously, the kind of interventions that they make in this panel will also be informed from that experience. Our third speaker is a familiar name for students at Nalsar. He's one of our alumni, Alok Prasanna Kumar. The third-year students would recall he was just here a couple of weeks ago speaking about the goods and services tax. Today, because of some other obligations, he's joining us online from Bangalore. But he's also been a strong supporter of this conference and has attended the previous editions, and we hope will attend the future editions as we keep organizing it. Alok, of course, as you know, is currently with the Vidhi Center for Legal Policy in Bangalore. But most of you have seen his work largely in the Economic and Political Weekly in recent years, where he writes specifically on law and society and has created a fair amount of work on not just the judicial system, but also substantive areas such as financial federalism, urban planning, to name a few. So for this panel, the coverage that we had in mind is not exactly focused on doctrinal developments. That will be the focus for some of the later panels. But since the title of the panel is Media Ownership and Viewpoint Pluralism, the basic thread that we thought that we should develop is not so much specific decisions or specific controversies about viewpoint pluralism, but essentially the underlying reasons as to how we have arrived at the situation that we are in right now in the Indian news market. The Telecom Regulatory Authority of India, in fact, had acknowledged the effects of the concentration of ownership in the mass media and the consequent knockdown effects it has on the nature of coverage in a report which they had put out in 2014. They were calling it a consultation paper, and there is a follow-up to that consultation paper in the last calendar year, which became the peg for us to connect this discussion with recent developments. But if some of you have had a chance to look at the TRAI's consultation papers, they're essentially flagging one principal problem, which is that the freedom of enterprise or the freedom to create businesses would be invoked by firms who are perhaps expanding their control over the media across different sectors. And there are different forms of economic concentration which have been analyzed. There are vertical forms of concentration, there are horizontal forms of concentration. And the TRAI paper is, of course, indicating that this trend might in fact be unhealthy for the lack of diversity that it leads to in the news content that we consume. So the initial emphasis was more on the broadcast sector in the 2014 paper. But if you look at the most recent consultation paper that has been offered, there is in fact a broader concern about the effects of the concentration of ownership in the print sector, the broadcast media, and also now, more importantly, the digital media. So while we could have looked at this issue from a very different lens, we could have had a group of people working on corporate law coming here and speaking about their understanding of what could be a regulatory or legal response to this issue. We thought it was also suitable to discuss this theme as part of our conference, because the fact that the landscape for consumption of news content or the production of news content has undergone substantial change in the last year is a known fact. But it does also shape the way in which we popularly engage with the content of the judicial system and the kind of decisions which are coming from it. So I'm not sure if we can really establish rigorous causal links between the patterns of economic ownership in the press and the kind of reporting that is happening on matters inside the courtroom. That's not really the rigorous link that perhaps we could establish here. But we could offer you a baseline discussion on how there could have possibly been other remedies which could have been tried by now, how there might be ideas going forward on how to ensure that there is genuine diversity, not just intellectual and cultural diversity, but also diversity of standpoints in the way in which we consume news, not just about public affairs at large, but also specifically about the courts. And that is hopefully going to be the focus of our discussion. So I'll first invite Apurva Vishwanath to make her presentation. Since we are running a little bit behind time, may I request each speaker to perhaps speak for 15 minutes, so that then we have considerable some time for discussion and to take questions from the audience as well. So I'll request Apurva to first come to the podium. After that, we will ask Vakasha to offer his remarks. Alok will join us, as you can see from his library. Is that your library or your room?
My study. It's my study.
Right, his study room. And then, of course, we'll have a discussion with the attendees here. Right, please come.
Hi, everyone. This is my third time here in Courts and Constitution, and it's always wonderful to talk about what we do in the newsroom every day, and link it to the larger conversations that we have here. But when we're talking about media ethics and pluralism, right? Siddharth talked about the TRAI consultation, and if you take forward from that, one of the overarching themes of the TRAI consultation is about what is pluralism in the Indian context, what is having multiple views in the media reflected in the Indian context specifically, and also about co-ownership. Can you have any regulatory regime to restrict ownership of media, and what are the ethical questions this raises? The last few months, we've all been talking about the Adani takeover of NDTV and what that means for the media landscape in India. Perhaps, there is probably no national television channel that is not now owned by a corporate powerhouse that way. So what does this really mean for the broader media landscape itself in India is a question we're still talking about and understanding. But before we talk about that, I wanted to, draw a distinction, which is something that the TRAI paper really doesn't talk about, is that is there a difference between ownership and effective control of a media house, right? And this is the essential question as journalists we battle on a daily basis. This is each story, each line in a story. It's the question that perhaps every journalist thinks about is, forget who the so to speak, the Malik of the paper is, where is the effective control of the news organization? Since we're talking in Hyderabad, if you switch on any of the Telugu news channels, right, you know what is the view of the organization. It doesn't necessarily have to reflect political ownership of these newspapers, which are very clear in sometimes. Right? So Sakshi is owned by the chief minister of the state. Another news channel. You know those. But even news organizations which are funneled through new money that's probably coming in from real estate businesses or other entrepreneurial projects, right? These are people who may not have their political patronage in one way or the other, but they're very clear about which way to go to. A very good case in point is Tamil media landscape. If any of you are familiar, there is perhaps no media organization which is not politically affiliated one way or the other in Tamil media. The Dinatanti, the MGR, the Karunanidhi controlled channels, the Gemini TV, every channel is very overt in what their political affiliations are. You take that in Kerala, you take that for any state, right? So this poses a particular problem that we all think about is where does the effective control of the channel lie? Even if it's not owned by a political party, who controls the channel? That's I don't know if many of the students here are familiar. There is a wonderful show on News Laundry called Nuisance. And one of my favorite lines from the Adani episode on that channel is, why did he really have to buy NDTV at such a premium? Because there were so many channels willing to do it for free. That reflects the state of affairs that we're also in. So regulation sounds like a great idea in that sense. And this is something that there are, the US and the UK have toyed with. In fact, in the US, I think from 1940s onwards, you've had some sort of media ownership regulation. Started with radio, of course. And in fact, even the US Supreme Court, despite the First Amendment, allowed this sort of restriction on radio monopolies in the US, saying that radio waves are very scarce, it's a very scarce resource, and the government action can actually restrict ownerships. So, but we've come a long way from that. The US doesn't have these monopolies anymore. It's consolidated, the market is consolidated into 4 big media houses, which is also the way perhaps Indian media will go in, the future. But, we talk about India and it's a very unique context because there are about 1.45 lakh registered newspapers and periodicals in India. And we publish in about 28 languages. There are about 900 television channels and about 30 24/7 news channels. And they cater to very diverse segments, unlike in the US or UK, where it's, largely one language and the context of what national is in these places are very different from what a national channel or national media means in India. For example, the paper I work with, the Indian Express, is a national media house, so to speak, but we don't have an edition in South India. We write about what happens in South of India, but we don't have a newspaper edition. So what is national? Is a Hindi newspaper a national newspaper? 3 Hindi newspapers cumulatively have about 71% of the market share. So are these, then can you say these are national newspapers as such? So India is a very peculiar context that way, right? Like in Telangana, if you see, with the change of a dialect, there is a whole new channel. The content in both the channels might be same, but Jai Telangana, for example, talks in a dialect which is distinct from its sister concern. And that's a new channel which focuses exclusively on one particular segment of the market. So ascertaining market share, ascertaining who's the dominant player are very complex conversations in India. And I don't know if regulation is going to be the solution to a lot of these. Inviting regulation is perhaps giving more control to the state and, putting free speech under question in different other ways, which we can't imagine right now. But, we're having this conversation in courts and the Constitution also at a very opportune time, because the last 2 years of the pandemic, if it has taught us one thing with the misinformation and the infodemic problem really is that even world leaders, even national broadcasters have peddled fake news or unscientific theories. And what we really get out of this situation is that there is no alternative to good first principles, real journalism, which is correct, which is neutral, which is fact checked, all of it, right? That basics is something that is more important than ever now. But when we talk about plural views, all of us agree that digital news is now touted as a panacea for having plurality of views, which is true. A lot of journalists, social media has been a game changer that way. Smaller news platforms, which are more independent, funded by the public, away from these traditional models of newspapers and news channels, which we think of, have come up. But there is also the fear of leaving out a substantial chunk of our population in this digital media landscape, with still barriers to education and internet accessibility. Digital media can't be the one-all panacea for all of these. So, all of this is still the problem statement, right? What are we going to do about it? We know that this new system as such, what we know today, is broken. There is no viable financial models. Everyone's trying to figure out what works. A lot of us have been looking at the subscriber model, which the New York Times, the Wall Street, the Washington Post, everybody is, trying out now. But what are the, in terms of solutions that we talk about, right? Where do you go from here is the answer really. And one of the things that we've seen in the last 2 years is the role of the public broadcaster as well. The Lok Sabha TV, the Rajya Sabha TV, which still has a huge market presence. In 2021, when the parliament session was ending, there was a conversation in the parliament on the Pegasus scandal and the farm laws, the protests which were happening at that time. The state broadcaster, that is the Lok Sabha TV, showed the opposition views on this issue discussed in the House for a grand total of 72 seconds, where the House functioned for 45 minutes with each opposition member raising these issues. Of course, everything was screened live on the televisions in the House, but public broadcasting, what you saw on TV, opposition was blacked out. You did not hear views of the other side. You only heard the minister speak. You only heard the chairperson of the House trying to, tell the opposition members to calm down, but you did not hear the voices from the opposition. And that is also a crisis that we are facing. So, strengthening our public broadcaster, bringing in institutional reforms there, looking at it in a more, like the BBC has standards for, what goes on television. As a public broadcasters, there are certain positive obligations on these institutions. That's something that we need to look at going forward. And, we can't not talk about the elephant in the room, which is the election year and the advertising money that it brings for everybody. Like, this is the year when newspapers will make money to pay salaries for the next 3 years. So here again, while there is conversation about state advertisement, right? This is an area where even the Supreme Court has intervened, said this can go as state advertisement, this cannot go as state advertisement. You need to have pictures of the Prime Minister, President, not everybody. If this has already been an area of judicial intervention. But what we leave out is the advertisement by political parties, which is a big part of campaign finance, the election push itself. So considering that, having political advertisement also under a similar structure of how we look at state advertisements, the government can shut off ads to a particular newspaper. And we've seen instances of this happen in the past in many times over. But the same political party which heads the government will still continue to put it ads in that newspaper. So this dichotomy of controlling advertisements is something that it will be very, very important this year, because more often than not, you see the BJP state head putting out an advertisement in a newspaper, you mistake it for the government of that particular state, which is also run by BJP, to be advertising on the same thing. And these are government policies that they're talking about. These are, So this is one of the big themes that we will see going forward in 2023 in the run up to the Lok Sabha elections. The other, issue that I wanted to talk about is, because we talk about the judiciary and intervention of the courts, there is an ongoing case where a bench headed by Justice Joseph is looking at hate speech in television news, right? There are observations that the court is making that this is unacceptable. The court is asking what is a self-regulatory mechanism that is being put in place? What are you doing about it? But what we've seen in the last few years is also a trend of judicial inaction, giving impetus to this hate propaganda on television channels. During the pandemic, when Tablighi Jamaat was a big issue, the issue came to court, in fact, very early on in the first week itself. What happened was the court heard and didn't do anything about it. So if you don't remove the high stakes from these issues, that relates to all the temple disputes that we are seeing right now, the Gyanvapi or the Mathura. Every hearing, inaction fuels more propaganda and more hate on television channels. You can extend that to a number of these issues that are live cases in the courts of India. Just an adjournment, pushing the issue forward to the future, is giving a 24-hour cycle to news channels to talk about it. And if there is timely intervention on these issues from the court, right, and that it takes away the high stakes from these things, they are not issues suddenly that needs to be shown 24/7. For example, one of my favorite examples, and that is the Aryan Khan bail case. The fact that it took 24 days for a court to decide that, and each hearing, each remand, each extension of the remand was a 24-hour news cycle, when all of that could have been done in maybe 3 days, right? Every time he's presented in the court, there is an entourage, and it keeps continuing. It talks not only about how reporting happens in courts, but also about how judicial processes can be used for a completely different purpose. While judicial intervention may not directly impact this cycle of hate on news channels, timely action, timely judicial decision intervention can definitely remove the sting out of it. That's one aspect of this. Siddharth talked about how this affects legal reporting as well, and this is something that, for example, Vakasha and I today asked your team not to live tweet what we talk. It sounds self-censorship like, and which is true. Reporting on courts is largely that. An individual views of a journalist are taken out of context, and there is always the sword of contempt of court hanging on your head, right? So with live telecast of court proceedings, a lot of you watch the proceedings, but what happens behind the scenes is what the public loses out if, because this happens every day. There are times when I've reflected on whether to report on whether a judge is sleeping in court when a death penalty hearing is happening. Or whether, a judge says this is too complex and I will not decide this 10 days before my retirement. These are conversations in courtroom which are very critical to how a democracy functions. But every court reporter thinks about whether you should report about these things, whether your organization will face consequences if you report on these things. So for students, of course, I'm sure the watching court proceedings live is an educational experience. It brings you the complex constitutional debates to you in very, very accessible ways. But what we can't miss out in that is what really happens for the court to be in that space that day, what happens before it. You see some of that in the work that Gautam Bhatia does, gives you a eye view of what happens when processes are delayed, what happens, why is inaction as important as what the court is doing. But that's also the job of court reporters to tell you that. What we see when we talk about plurality views, especially when reporting about courts, is that because it's about the court's views and what the court is doing than what the court is not doing. So mm, regulation, as a, as a journalist, I have a sort of an absolutist position on this, that more state intervention is going to be a problem, and it's only going to give state more power to curb on free speech and freedom of expression. In fact, from March 1st onwards, each television channel is required to show 30 minutes of content which the government deems is of national importance. Right? This is a regulation that has been made by the INB ministry, and the exemption is only for channels which telecast spiritual content or yoga content, because somehow that is deemed content of national importance. But everybody else, including your Sony TV and Star Plus, have to show 30 minutes of content which is of national importance. What this means, what is national importance, is decided by the government of the day. Thankfully, now it is only a voluntary declaration that the government needs from these channels, and May 6th was the deadline for that voluntary declaration. From watching these channels in that 1 week to see what really they come up with, in the last 2 months to see what they will come up with, has shown one thing, that the media has subverted this government regulation in a very, very interesting way, which is by saying that when we telecast a Saas Bahu serial, it shows Indian culture and tradition, and that's also of national importance. So it's an idiotic answer to an idiotic regulation. But the fact that we have a state mandate to show 30 minutes of content that is of national importance is worth noting. This is essentially what state regulation on media houses would look like. We started talking about all of this, largely where we took off from was the Adani takeover of NDTV. But beyond that, what are these spaces like? How much corporate interest do they represent? And also how it is reflected in every day when we talk about these issues is something that we will have to pay more attention going forward. Transparency is one way. Do you know when you switch on a channel that this is owned by XYZ? There are district level politicians who have their own media channels now. The entry barriers are quite low, and it's not really a cost for a politician to open his own channel and just have that vertical penetration. But you tie up with a cable news network, and you have your own channel broadcast when you switch on the TV. So transparency is probably one area where telling the viewer, but how much of that will really make a difference is something that is also a question. Does it really bother the average viewer that this is funded by XYZ? But at least having that information is important for the consumer of news. Then he can switch between, which view that he wants to take. Because one of the things about the Indian market is that there are so many segments that you can cater to, that you really can't be on just one side. You have to have a multitude of, and a very good example is the Mirror Now and Times Now example, right? Mirror Now would cater to civic issues, would talk about potholes and shoddy roads and buses not coming on time, whereas Times Now would have a completely different broadcast the same day on, Bollywood on drugs or something like that. The fact that both are owned by the same entity and both are catering to a different segment is testament to that, the fact that they recognize that in India you need a plurality of views, or your audience is that wide for you to include all of these views. So yeah, these are some of the issues that we wanted to talk about in this election year especially. And I keep stressing about that because you have a government that could enter its third term, and the advertising model of news is going to be crucial than ever this year. Thank you so much.
Thanks, Apurva, for in fact broadening the context of the discussion. Rather than just talking about the patterns of ownership, I think you were able to do a good job in outlining what the larger ecosystem looked like in the past, how has it changed, and what is likely to be the escalation of this problem possibly in the next few years. So I'll just ask Vakasha to now add his remarks. And may I just request if you can just keep it to 15 minutes, then we'll have some time for discussion.
a timer here to make sure that I'm particularly bad at following times. Okay, so I think the good thing is that Apurva's already touched on the big elephant in the room, which is Adani taking over NDTV, right? But what's interesting about that case is actually it goes back even further. The way through which Adani sort of got his claws into NDTV was through a company which was known as VCPL. As some of you who followed it in a lot of detail would know, that's where he first got his chance at getting his teeth into it. VCPL has a very long history, and it goes back to around sort of when you had the recession time in 2008 and stuff and all that, where media houses in India were in a bit of trouble. Like they'd overextended themselves. At that point, it looked like a golden age for media pluralism in India because you had suddenly the private sector had opened up. All sorts of people were buying and setting up channels, and it looked like a very good time. But it all came crashing down because of the recession. These media houses had, as I said, overextended. They were paying people ridiculous salaries for doing very little work, which is, I mean, it's the dream, obviously, but it's not something which all of us get to do. But the thing was that at that point of time, a lot of these media houses needed loans. They needed support to be able to survive. And very cleverly at that point of time, Mukesh Ambani in particular was very smart about this. He directly went to Network 18, offered them loans, which were then convertible into shares, which is how Raghav Bell lost control eventually of Network 18. But he also did a lot of other things. So he set up threads of entire subsidiaries, which went and made investments into a bunch of other media houses, including, as a lot of people eventually only later got to know, including NDTV. So it was that VCPL entity which allowed Adani to take over had already been it was there because of Mukesh Ambani for 10 plus years. Now, what does that tell us about media pluralism in India? It tells us that there have been attempts to take this sort of ownership and control for a very long time. It tells us that there are certain factors which can come in and completely change the game. Now, you can have whatever regulation and rules and stuff as you want. When a recession comes along or some other particular crisis comes along and creates a crisis in an industry, how are those people expected to survive? We don't want, we can say, okay, let's put in a regulation saying no corporate media house can take control. But then what is that media house going to do? Should it shut down? Is that actually in the public interest at the point of time? So I think similar to Apurva, I think I have concerns over this idea that, okay, can we bring in regulation? Because I think there's a lot of questions of how you would do it, right? In the TRI consultation paper, which Siddharth talked about, does to some extent reference it. It talks about, oh, what would you do for defining the relevant market under competition law? Could you create a public interest regulation which would stop certain kind of groups from taking control of companies? And on paper and in theory, that would be great. But in practice, I think that's a pretty impossible situation in general. And as Apurva has pointed out, given the landscape in India for the media, that becomes a particularly impossible job. So there's that, which kind of means, so should this talk even continue then? Because if we can't have it, then that should be the end, right? Well, not exactly. Because one thing is that, okay, look, even assuming there was a workable model, you could figure that out, you could do something of all of this, how would it have to be implemented? Through legislation, through rules, through regulations? Do we really think that would be ever possible in this country at this point, going forward, next 50 years, let's say? And maybe I'm being pessimistic, but not really possible, right? So instead, we have to look at other options to achieve a similar objective, perhaps. Now, so what is the real point of media pluralism? It is that journalists can do their job. You can get opposing points of view, which for the public, they have a right to be able to access opposing points of view, things which are not in alignment with what the government is saying, not in alignment with what the big corporate houses are saying. So what are the ways in which you can do that, right? The key thing, and I think this is going to be the focus of what I want to talk about here, is protection of journalists. Because when you're unable to protect journalists, whether it is journalists at an independent media house, or it is journalists in a sort of legacy media house where there are pressures, but who is still trying to do their job, these are the people who are going to give you the same spirit of what you need with media pluralism. And right now, our systems of protection for that are, I mean, I don't want to say it, but it's terrible. Let's use a parliamentary word for that. Now, the reason is that let's look at what are the ways in which this takes place. The big one, which I think we're reasonably aware of is criminal cases against journalists, right? So you have, it's not as though we don't have independent media with opposing points of view. Yes, there are concerns about how much reach they actually have. Like at the end of the day, now I work for the Quint. At the end of the day, no matter what we thought we were doing, how many people were really reading us, or at least how many people who were going to have their minds changed were really reading us? Very small, wouldn't necessarily cause much of an impact. But at least the voice is still there, right? So, and there are so many places doing that which are still trying. So what do you need? What are the ways in which you protect them? Well, look at the ways in which they are being attacked, right? You have using the ED, using the income tax authorities. That's one route. The other route is criminal cases against journalists, which is a huge problem at this point of time. Now, for instance, in the latest, I think, thing on the sort of press freedoms index right now, there are, at the end of last year, it was pointed out 7 journalists are in jail. But it's not just, you know, the 7 journalists who are in jail. It's all the other journalists who go to jail for a bit and then get bail, but like it's taken them 2 months, 3 months, 4 months to get that. Like that doesn't get counted in that list at the end of the year, but they've spent that time in jail, right? For instance, like the list last year included Siddiq Kappan, who'd been there for almost 2 years, right? At this stage now he's finally out, but I mean, so now he's no longer on that list, but it's there. And I think everyone who follows the media, who is in part of the media, knows about these kind of cases. It's the case which is filed, which doesn't even lead to an arrest, but now means every time a journalist is trying to go to a particular place, they ask 10 different questions. A journalist can't leave a country. Like my colleague Poonam Agarwal, who had a case under the Official Secrets Act, could not leave the country, even though it was a completely bogus case. And this, by the way, ties into now what Apurva was talking about, right? You have inaction by the courts. There are multiple, every time these kind of cases come up where journalists are facing this kind of intimidation, the cases reach the court quite fast. I mean, of course, again, this is luckily the journalists who have that privilege. There are many journalists who won't have that, right? Many RTI activists who don't have that are thrown in jail, are stuck in those positions. Many of them are even killed at this stage, as we're well aware. But the point is, you know, when it comes to these cases which go up to the courts, are we seeing enough action? In some cases, yes, Arnab Goswami gets action. Mohammad Zubair got a little bit lucky. That the Supreme Court in a relatively short period of time gave him bail. But the question was, should it have even got that far, right? Because by the time Zubair went to the Supreme Court, he had already tried going to the High Court for quashing and asking for an interim relief, which was just roundly denied without any basis provided by the courts. So what we see is more than enough times, these journalists are facing a situation where the courts are not taking action to protect them. And, you know, the list of people, and the thing is, see, at least, you know, we know Zubair's case. But at the end of the day, Rupesh Kumar Singh, he's an independent journalist who was one of the people against whom Pegasus was used. Everyone talked about him then for a bit. He's been in jail since July last year. How many people are aware of that, right? How many people are aware of the fact that he's trying to get bail, but because, oh, he's involved in Maoist funding, so UAPA comes into place, and therefore he's stuck in the courts, which do have the power, despite Watali, despite everything. When it comes to UAPA, there is still a power for the courts to actually look into, you know, is there a prima facie case or not? Which courts do that? Lower courts, almost none. High courts continuously try to evade that responsibility, even though they have that power. And the Supreme Court has played a role in this, right? At the end of the day, you had the Delhi riots case with those 3 activists, Asif Iqbal Tana, Natasha Narwal, Devangna Karita. Excellent order by Delhi High Court on principle. What does Supreme Court do? Oh, we're not, you know, stopping them from getting bail, but we will stay this judgment can't apply as precedent. I mean, what does that even mean, right? Now, even though technically a judge could independently use the same reasoning, and some have managed to do that since, it's something which then sets into the mind of a judge going forward. And what do you do about this, right? There are 2 journalists in Kashmir, Sajad Gul and Fahad Shah, who write for the Kashmir Wala. They've been in jail for ages now. There's PSA cases lodged against them. With Fahad Shah, the situation was an article published 11 years ago when he wasn't even there at Kashmir Wala. That article was being used to create a UAPA case and put this man in jail. So how does this really work, right? Like, as in, how are the courts letting this kind of stuff happen? And does this mean that there is actually something that can be done? And I think the answer is yes. The courts have to learn that you've got to step up and do more. And the Supreme Court can play a role in that. I mean, if it ever decides to. I mean, luckily, Justice Bhatt is not here. But I mean, like, the Supreme Court could do more. And there are ways in which of course, the question becomes, oh, but then how do you structure that, right? Do you want to have more interventionist rulings? Do you want to have a situation where the courts are stepping into domains which they don't necessarily need to? And yes, we ideally don't want that, right? We don't want some vague, flaccid PIL jurisprudence being created, which is then used to do this. So what are the ways in which you can concretely make that happen? I think one of the things we can look at is making sure that there is, first of all, an understanding of the right to receive information. Now, we have this, it has been over the years sort of brought in the Indian jurisprudence concept. It is there. I mean, there was a brief mention of it back in Bennett Coleman, but not expanded on in a lot of detail. In 2014, when we had the rulings on making sure criminal antecedents have to be published, suddenly right to know came back into vogue for a very brief period of time, but then it's been lost. And it was basically talked about in the context of elections, that if you need that, elections are substantial part of democracy, people have to exercise their freedom of speech there, and therefore they have to have a right to know for elections. But what about the right to receive information in general, right? That is crucial to your right to freedom of expression. And while it has been signposted in some judgments over the years, even the privacy judgment did bring in a bit of that, it is still not something which is fully appreciated in the context of the media and the role they have to play. And this is something which perhaps we could see the Supreme Court or High Court step in to build on that jurisprudence to then actually add some protections for journalists. So whether that could be making sure that these cases against journalists are heard faster, making sure that, I mean, there's a controversial idea which was partly floated during the Vinod Dua case, right? Where they said anytime there's a sedition case against a journalist, if they're a journalist of 10 years standing, then it should not be allowed to proceed until it's been reviewed by a particular panel and all of that. The question is, I mean, can there be some sort of system like this for any case against a journalist, which is not something like, say, obviously murder or, some case where they've accused of bodily harm or something, but anything which is technically related to their exercise of speech in some way or the other. Cases like that, should there be a way in which you have some sort of preliminary screening, some sort of system set up? Because now, at the end of the day, yes, we don't have a separate right to freedom of the press in India, right? We have to derive it from the right to freedom of speech and expression. So should journalists be given some special treatment here? Well, I mean, on paper, you could say no, but if we then emphasize the right to receive information for people, then that can be justified. So that is something which can perhaps be looked at. One of the other things which has to be done, which is just not done at all, is where do we ever see action for illegal arrests, right? When arrests are taking place in violation of Arnesh Kumar, no action is taken against the police person who does it. When we have a case being filed which is completely malified, right? So there was recently a case against another Kashmiri photojournalist, Manandar, released afterwards. The court has found that there's no basis for a UAP case against him. Now, at this stage, should there be consequences? And at this point, despite all, if we don't have some sort of consequences, whether it's for the police officers or whether it's for even people who are involved in those cases, there is never going to be anything. Again, this is a place where the court could play a role, but so far it has failed to do so. Now, this is something which, let me see, how much time do I have left? Okay, so I have 2 minutes left, so let me try and very quickly go through some stuff. Okay, so as I said, the right to receive information, I think we need to develop that jurisprudence. That is something which the courts can do. It can do that within cases even before it. We know there are challenges under the Right to Information Act, which are currently before the court and not, about the amendments being made there. Some have already been dismissed. Some are still sort of there in the pipeline and nobody really cares evidently at the court because, I mean, again, in action. This is why we don't want our comments live tweeted. But the point being that you have the ability to potentially pick this stuff up. In terms of other ways of how we can achieve this, through not just the courts or not just through sort of aspects related to, bread and butter criminal law, state advertising, that is something which Apurva talked about here. Now, there is some precedent for how you can bring in some regulation on this, which could work. And this is the kind of regulation which could perhaps even be brought in by the Supreme Court through a judgment rather than going through the legislature. Again, that's not always ideal. So, I mean, I know there will always be criticism of that approach. But the question is, we do need some way to prevent state advertisements being used as a tool of extortion, because that is something which happens, especially with the print media, that if they don't like you, they take it away and they're like, oh, we'll give it back to you if you start doing this. Now, many of you may remember there was a photograph, this had happened to the Hindu, and then 2 days later, the Hindu, not 2 days later, it took a while. And finally, the Hindu's editor and other people went and they sat with the Prime Minister. And then miraculously, suddenly after that, all Enram's coverage started to get very negative treatment by his own organization. So now that's something which we want to stop, right? And there is some examples of how you can bring this kind of regulation in the EU. They have some of this out there. Of course, how do you fully adapt that to the Indian context? How do you bring it in a way which isn't necessarily reliant on the government doing it, because we know they won't, is perhaps again through the courts. But this takes us back to a problem where we're constantly having to rely on the courts to do these things, which is not really going to help. So are there other options? Maybe not through the courts. For journalist houses themselves, there are some things they can do. Journalists can try to do to protect themselves. I mean, unionization is one thing, but I think, as we all know, the labor laws in India are currently all stacked to prevent unionization, which would have been great otherwise, right? Because technically unionization would protect even journalists at media houses which are facing pressure, because they can't be fired, right? Because what is the big, at the end of the day, how is media pluralism, how does it become a problem, right? It's when a media house which tries to be independent gets squeezed, in addition to obviously journalists facing cases. It's when they lose their opportunities for funding. So if those things are no longer possible, because the easy thing is then they fire the journalist. So the journalist knows they have to self-censor because they could face losing their job, or they could face trouble for certain things. So protections for journalists, not just in terms of the criminal cases they face, maybe unionization, but again, difficult one to do. One final option, which is interesting because it possibly gives it a route, is the TRAI route. Now, this is something which Siddharth has touched on, the fact that they released a consultation last year. There's another consultation this year by the TRAI on convergence, where they're like, oh my God, nowadays audiovisual content is not just what you see on TV, it's also all the streaming stuff. It's all these things which used to earlier be separate entities and could be regulated separately, but now you've got to think about a convergence of regulation and looking at them all together. What TRAI is sort of, from what we know, is trying to do is it's trying to save itself, because it's pretty much, it's losing a lot of its relevance. It's losing a lot of its ability to actually have an influence on policy. So what it is trying to do is position itself as this kind of independent media regulator and as an entity which can play a role in trying to do that. Now, this provides us an interesting opportunity. If there is actual appetite for TRAI to do this, and it is able to get this kind of ability to take on this kind of control, perhaps we can find ways to slip in regulations, changes, things within TRAI's remit, especially if, say, TRAI's independence is protected in certain ways, which again, we might have to end up trying to run to the courts to do that, but not great. But the point being that through TRAI's attempts to try and save itself, we may be able to find ways to give it powers as a regulator, which, as an independent regulator though, rather than as a government agency, which is what it is technically supposed to be already. But we give it more, we protect its independence more and give it the ability to maybe interfere in certain ways which could protect journalists. Now, one of the things is, for instance, we talked about self-regulation. There's, in the context of TV channels. Now, on that front, at the end, we've seen now recently a bunch of orders again against News 18 and others, which are supposed to be, helping stop them from spreading hate speech. But what is the punishment? 1 year later, after you've published something, it's achieved everything it achieved. It got you all the views, it got you your monetization, it got you your eyeballs, all of that. 1 year later, you're fined 1 lakh. I mean, for a small outfit, maybe that 1 lakh is important, right? But like, we're talking about big TV channels here. Like, do you think News 18 cares about that 1 lakh? They don't. They could be fined 1 lakh 10, 15, 20 times over. It doesn't matter, because they're still getting more than enough money elsewhere. This is where an independent regulator could, for instance, come in again, have more timely orders, have better actual punishments. So this would help prevent certain, the way in which the media represents things which all allow it to be focused in one way, in one viewpoint, whether it's on culture or political issues, can be perhaps addressed. But I mean, this is a very hopeful idea. I think there is an opportunity, because TRAI is trying very hard to create this. So maybe we can find ways to do that, but let's not necessarily hope that that's going to be the case. So to wrap up, I think at the end of the day, if we're really not going to, I don't think state sort of regulation and ownership in a very coercive way is going to help. I think Abu was absolutely right about that. Don't give the state more power. You'll get more ridiculous kind of ideas and things which they want to do. Try to keep it. So therefore, don't try to apply a model which may be useful elsewhere. Because of India's unique market, that will not work. So instead, look at what are the real effects, what are the problems underlying at the heart of all of this, which is protect your journalists, protect their ability to do their job, whether that's through giving them the ability to do it at their own company, whether that's about ensuring they can get funding from other sources, whether that's about ensuring they don't get bogged down in stupid criminal law cases. And yeah, I mean, transparency hopefully will be something which can also be used to build the case for all of this going forward. It is in itself not going to change it, because we know, for instance, that viewers who really want to watch what is on Republic are going to go regardless of who owns it, or Times Now, or any of these people who are going to want to, I mean, we've seen with the Adani response, right? Look at how many people who are not even the Adani trolls, and of which there are many, who all came out to support Adani over like the Hindenburg thing. You think they wouldn't necessarily, do you think these people are going to care about Adani running NDTV and therefore NDTV news being covered in that way. No, then they're not going to care. So, but in the long term, media transparency is a good thing, and it's something which we should hopefully work towards, because it helps us when we understand that we will understand the way things happen with the way the NDTV situation happened. As I started with the way another corporate house had actually tried to take over this and had very secretly been trying to control it in certain ways. This is happening all the time, even over What's Left and other places which are there. So that is an important thing, and I think, yeah, I've gone over time, so I will run away now at this point. But yeah, I hope this gives some food for thought for everyone here.
Yeah, so before we move to Alok, I think for some of the students, I just wanted to clarify that the TRAI consultation paper was initially talking about two specific interventions. One was to place quantitative restrictions on cross ownership, which means preventing the same firm from having stakes in different kinds of media. But there's also the process of integration in the media across different outlets. And there were also some suggestions on that. But I think both of our presentations have looked at the issue from a more realist perspective. I think Apurva was talking more about it from the perspective of how the news market is structured, whereas Vakasha was able to bring in a perspective that focuses more on the interests of the journalists and what sort of direct impact might exist for them in the existing climate. So now we'll hear from Alok, who himself is not strictly a legal journalist. I think I'll leave it to him to clarify what his current avatar is. But Alok, before you start, I should just tell you, since you're speaking online, your voice, I think, will be projected all over the room. So I think even if you speak in a normal tone, we will be hearing you. I mean, basically, I'm saying your voice will be louder than it actually is to you in your room.
Thanks, Siddharth. And I will keep my tone as conversational as possible. Good afternoon, everyone. I would have loved to be in Hyderabad. I always enjoy courts and constitutions events, mostly because I get to hang out and talk to people, my co-panelists, and also all the students. But unfortunately, this weekend was not possible. Everyone can hear me, right? Okay. So I want to build on a couple of themes that have already come through. I think Apurva and Vakasha have done a wonderful job of highlighting some of the points that I had intended to make. But I want to go a little bit deeper into that. And before I start, I want to read out a quote from a recent piece of media, which I think illustrates what I'm trying to say very well. It goes something like this. The need for control is so desperate because it is so unnatural. Tyranny requires constant effort. It breaks, it leaks. Authority is brittle. Oppression is the mask of fear. Anybody want to identify where that's from? I guess you won't be able to say it, but this is actually from a wonderful, wonderful TV show called Andor, which, even though it's set in the Star Wars universe, it's nothing like anything that Star Wars is about. And there is something called Nemec's Manifesto in Star Wars, which has this particular point. And what I want to sort of start off my talk, so to speak, and I won't take too long, are three things to sort of keep in mind when we're having this discussion. One is that people are not sheep. They are capable of discerning the truth from the facts. It may be more difficult sometimes, it may be easier at other points of time, but people are capable of doing so. Two, people don't always just consume one form of media and assume everything that it says is absolutely true. There may be some people who do that. There may be different categories, but as Apurva has sort of pointed out to us, this country is such a crazily diverse market that it's very, very hard to assume that everyone hears the same thing all the time and therefore believes in the same thing all the time. The second point that I sort of want to make, which kind of underpins our discussion, is profit per se isn't bad. And here I sort of bring my personal experience of having been part of continuing to be part of the strategy team of Vidhi, is that even if you're a not-for-profit, like, you're never going to be in a position that I think we have enough money, we're good for the next few years. We would like that little bit of extra cushion. And whether you're the Wire, which runs as a trust, or whether you're Ravish Kumar, who has just started off his YouTube channel, let's not paint it as if they make a little bit of surplus, that's per se bad. That's not true. A lot of media organizations are also structured as for-profit companies. So if we can't dismiss any for-profit entity which runs a media outlet of some sort as per se bad or per se unacceptable to the cause of the free press. Third, and I want to kind of highlight and go a little bit in depth into this, direct control is very hard. The reason why I sort of say this is that uh, it is time consuming. It is enormous effort. Implicit in a lot of our discussion about the Adani group taking over NDTV is that somebody is going to be sitting from Adani headquarters and dictating every single piece of news to NDTV what they should and shouldn't cover. But it doesn't work like that, right? I think as lawyers, we have to kind of, when we are talking about media ownership and diversity of views, we have to keep in mind that the legal fiction of ownership and the legal definition of control need not necessarily result in the direct control or direct ownership of the way in which news is presented or opinions are presented. Not to say that it cannot possibly happen, I'm sure it does. But if we have to understand what the problem is, we can't leave it at a superficial level that, companies which are close to government are therefore more likely to favor government and therefore our news media diversity is getting affected. I think we need a more nuanced understanding of the problem than that. Which brings me to the meat of sort of what I want to say, which is that it's not actually perhaps control of the media which made someone like Gautam Adani buy the NDTV group. It's possibly because they were making a profit. And as a company which is heavily over leveraged, as a company which is sort of, needs various cash flow, various sources of cash, perhaps NDTV was bought because, it just happened to be profitable. NDTV was perhaps available only because all the other news channels were already taken. But let's not forget that nobody particularly wants to buy a news channel and pour money into it as a loss-making enterprise. Otherwise, then they won't have to worry about TRPs or advertisements or anything. Everybody would be running it for free as their own PR channel. That's generally not how it works. But what is it that affects media diversity? What is it really then that affects media diversity? And I want to make this point that even those who want to control the narrative are aware that it is probably not realistic to operate in the way that perhaps the Soviet Union did, or maybe China does today, or Nazi Germany did, which was to round up all the newspaper editors, tell them these are the headlines for tomorrow, you print this and nothing else. Because what inevitably tends to happen is it doesn't take too long for people to realize none of this is credible. None of this is particularly worthwhile. Even China, which runs the great internet firewall, cannot keep out all information, cannot prevent people from finding out what's happening. And you see that in the way people responded to the crackdowns and the overbearing regulations on COVID. You cannot entirely control the narrative. And at some level, tyrants are aware of that. But this is where, at least what needs to be understood about what's going on in India is that you don't need complete control. That a more effective tool, so to speak, might be arbitrariness. That the government recognizes, or whoever wants to control the media landscape and diversity of opinions recognizes that I just need to be arbitrary in my action and people will self-censor themselves. And one example we can sort of see this is the fact that the very same Amazon, which owns, or well, let's say Jeff Bezos, who owns Washington Post, can freely write, pretty much more, even about Amazon itself, maybe not beyond a particular point, can write about Amazon, can write about the US government, can write about various political parties. But an Amazon Prime in India thinks 300 times before putting one gali in a TV show. And this is possibly because Amazon Prime, and this is more or less fact, has been burned by the experience of Tandav. Because it's not as if there was a clear governmental guideline which said you cannot do this. It is the sheer and total arbitrariness of the action taken against them by the police that basically said we can't, we don't want to take this risk. We don't want to even come close to crossing the line. We want to stay so far behind the line. We want it to be so inoffensive that nobody will even think about saying, anything controversial about what we are saying. So in that sense, arbitrariness prompts self-censorship. I think this is a great point, I think, made by both Apurva and Vakasha, that regulations, for better or worse, people find a way around it. And one of the things that you can say about this country, I don't think there's a regulation or rule or law that people haven't found a way around. And no matter how overbearing, how burdensome regulations government, I think the great example that Apurva gave kind of makes this point that for the government, making regulations means you're just inviting people to say, please find a way around this. When we say 30 minutes of public interest broadcast, it's not like they're going to take the video of some BJP affiliated organization or some government body and just put it there. They say, Saas Bahu, TV serials are good enough, national integration. Maybe Star Sports will say, we just broadcast 1 hour of the Narendra Modi and Anthony Albanese event from Ahmedabad. That's 1 hour public in public interest, national interest broadcast. So making rules, regulations doesn't really work. It's actually arbitrary state action which prompts the self-censorship. If you never know what you might face consequences for, what you might sort of be punished for and hauled up for, you will stay well behind the line. You won't even go close to the line. But there's a flip side to this. And this flip side has been highlighted by both the previous speakers. And I don't want to repeat what Apurva and Vakasha have already said, except to say that our courts have consistently failed to check arbitrary action on the part of the government. And I don't just mean directives of the MIB saying cut this or cut that. I don't mean the censor board saying don't show this, don't show that. I mean down to the level of the average police who files an FIR based on completely fictitious, imaginative readings of texts and articles, or comes up with completely fake UAPA cases against the likes of Siddiqui Kappan, the examples that Vakasha gave. And you have courts which just nod along, say, okay, sure, bail denied, pretty much for the next 2 to 3 years. No application of mind, no serious consideration of the facts of the case, no serious thought given to principles laid down by the court. You just simply say bail denied. And why does this happen? Right? And this is where I think we need to go one level deeper to understand the true problem, perhaps with the judiciary in India. And it is not at the Supreme Court level. To slightly disagree with what Vakasha just said, it's not at the Supreme Court level, it's at the High Court level. And specifically the High Courts, which have administrative control over the subordinate judiciary, or at least the constitutional term is subordinate jury. But as Chief Justice Chandrachud has said, and as a lot of people believe, and I personally believe, I think they are constitutional courts as well. We should call them trial courts of the district judiciary. The term subordinate judiciary fundamentally does disservice to the nature of the work that these judges do. But here's the thing. They face the threat of repercussion and consequences for every single order that they pass. And that is built into the system. When we have said that the High Court shall be in charge of the administrative control of the trial courts, what it means is that every month, every quarter, every year, you're being assessed by the portfolio judge in the High Court, looking at the performance of all the judges in the district. And somehow, this has meant that you're never going to reward someone for being liberal with bail. Correct me if I'm wrong, but I cannot think of a single instance where a judge who has been prompt and thoughtful and constitutional and legal in their assessment of bail orders has had their career accelerated. It is more likely that they have been hauled up by the High Court saying, why are you granting bail so much? It's more likely that they have had show cause notices issuing saying your bail order doesn't make sense. And you will find this reported on a fairly regular basis in live law. It was only very recently, I believe it was Justice Lalit's bench in the Supreme Court, which kind of hauled up a trial court judge for refusing to grant bail on what is a very simple and straightforward case. Obviously, you can't do too much to the High Courts because the Supreme Court doesn't have administrative control over the High Courts. You can only impeach a High Court judge. But the fact remains that our system incentivizes the trial court judge, the district judge, to essentially ignore the law, protect your career, and protect your reputation by denying bail, right? If you deny bail, no one's going to ask a second question to you. If you say that a prima facie case is made out, even if somebody disagrees, it will be seen as a disagreement on the norms or disagreement on the understanding of the law. Hardly anyone says this is such a bizarre reading of the term prima facie case that you should be hauled up for it. And we have therefore a system which believes that if you just accept the police narrative, deny the bail, you'll be fine, right? And this is an area which unfortunately not enough solid research is being undertaken, not enough solid empirical. I mean, there are beginnings of it happening. There are beginnings happening in various American universities and among Indian institutions. But can we have a number on how long does it take the average under trial to get bail in this country, right? And let's ignore, say, even those whose petitions are pending. Let's just say those who got bail, how long did it take to get bail? And these are classify them into bailable offenses and non-bailable offenses. So the reason why I'm pointing to this is that as a entity which owns a media organization, even if you have the most enlightened oligarch in this country, let's say, who wants to ensure the most independent, fearless media organization to ask difficult questions of power, you do not know where the blowback will be. It's not as if the media, it's not just only that the journalists of that media organization will face consequences. Your other businesses will be attacked. Your other businesses will suddenly find licenses lost. Your other businesses will suddenly find facing CBI and tax and various other inquiries. Your other businesses will suffer. So, in effect, perhaps what we have to think about is that the one element of this, of course, is what I have described, which is that you cannot really address the lack of diversity in viewpoint simply by looking at questions of ownership and control without understanding the nature of how this control tends to get exercised. A lot of it being self-censorship, and that is prompted by the arbitrariness of government action, which is unchecked by a judiciary which fails to see itself as defending constitutional rights and is really more oriented towards career progression. And that also means that irrespective of ownership, right, irrespective of the legal fiction of ownership, you are forced to self-censor as an entity, whether you're a large multi, sector conglomerate with tentacles everywhere, or if you're just a small media house which just about manages to keep a newspaper going. You are always on the lookout for on which direction that you might be hit, and you cannot really rely on the courts. You may eventually get acquitted. You may eventually find that you've gotten a favorable order or judgment, but in the meantime, given the delays in the judicial process, given the lack of that orientation to address these problems as not just a case but as serious constitutional issues, you will find that there is going to be a serious restriction of diversity in the media. And I'll finally end in this one thought that we cannot really talk about the state of free speech in India without looking at the state of the rule of law. You cannot provide a solution to this problem only from the lens of free speech without fixing the deeper problems with the judiciary and rule of law in this country and the lack of independence. When I say independence, I just don't mean we are obsessed with appointments in this country. We think if you get an independent person appointed in an independent manner, the institution will function independently, and that is simply not true. It's empirically not true. It's normatively not true. But unfortunately, that's where our obsession goes to it. We don't consider how independence is a much richer concept, and independence of the institution is a much richer concept. And unless we have those tough conversations, unless we look for solutions to the problem which work across multiple areas and issues, we are not going to be able to fix this particular problem only from the lens of freedom of speech and expression. So I'll stop there. Thank you so much for inviting me, and thank you so much for obliging me by allowing me to speak online from the comfort of my home in Bangalore. I hope to be back at Courts and Constitution, and I'll hand it over to you, Siddharth.
Thanks, Alok, for tying the threads together from the previous two speeches, but also adding your own analysis on why regulatory solutions, of course, may only cover a limited part of the debate. It has more to do with questions of institutional independence and personal independence, which in a way are normative questions and really can't be addressed just through formal legal intervention. So we just will take a limited number of questions because in the next panel, we have a couple of speakers who are joining us from abroad. So we do need to catch up and make sure that that panel starts on time. The speakers are here over lunch, so which means if you want an extended conversation, you can speak to them. But if somebody has specific questions for the speakers here, and Alok, please raise your hands and we can have some discussion. Okay, so I'll just identify them. There's Yashasvi, there's Utkarsh. Anybody else? Okay, Shreyam. So let's take 3 questions and some Ved. We'll collect questions. I think that will be faster. Right.
Hi, I'm Yashasi from the fifth year. My questions to the panel at large. We've spoken about difference between actual control and effective control. If we go into effective editorial control, even the Adani NDTV takeover, there was conversation about how NDTV will maintain editorial control. Can those structures come in place through, let's say, employment contracts of journalists or bylaws of the organization itself? Can we create editorial independence through, let's say, we know we don't believe so much that the regulator will be able to help so much, but can, let's say, TRAI say that every media organization has to have certain editorial independence clauses in the articles of association of these entities, which will lead to diversity of viewpoints despite there being a consolidation in the ownership?
Right. Let's collect the questions. Yeah.
Hello. While we did talk about the private ownership of media, could we also look at state ownership of media? As in, for instance, specifically in the case of a radio, it's only the state that can broadcast any news. And since I think the state-controlled radio is the most widely consumed radio channel in the entire nation, the people's perception of news events runs the risk of being modified by also in the realm of TV, for instance, in Lok Sabha and Rajya Sabha, we often see opposition speakers being cut off at crucial moments in time. And that could also be, a manifestation of political control. While there have been attempts to make it more neutral, could there be, more laws to curb that? That's my question.
Right. There's one more question behind you, Samved.
Hi, yeah, I think my question is to, I'm Samved from the third year. So my question is to Apurva, but it also links to what Vakasha talked about, the right to diverse viewpoints. In rural spaces, I think you mentioned in your presentation as well that there is a lack of digitized news, but it's not just digitized news. There may not be a lot of access to diverse newspapers or even news channels, for example, on television. So how do we ensure viewpoint pluralism in rural spaces in India when there's especially a dearth of these diverse viewpoints even reaching that, percolating down to that level of Indian society? Thank you.
Okay, there are two more. Should we take them or do you want to respond? Or can we take two more? Okay, so I think Shreyam and then Vivek Reddy. Yeah, just Shreyam, just get the mic quickly. Yeah. No, we are also recording. So technological constraints.
Yeah, so my question is to Alok sir. My question is basically, he talked about how rules and regulations can essentially be bypassed and worked around. And then we also have the judiciary, especially at the high court level, having administrative control of the trial courts and the lower courts. So what solution or what framework in essence are we looking at when we don't have efficient rules and regulations? We don't have an efficient judiciary who's not acting up in time and not providing bails essentially for lack of career prospects. What kind of a solution in some specific or definite framework are we looking at if we don't move towards rules and regulations or judiciary? Are we looking at, let's say, principles of natural justice within the judiciary itself so that despite the absence of certain rules and regulations, we can abide by these peremptory norms and which can, let's say, somewhat or vaguely lead to some definite conclusions? Like, what is the solution to this if we don't rely on rules and regulations and the judiciary?
Okay. Senior Advocate Vivek Reddy.
No.
It should be on, yeah.
I know this triggered by what you said. If I'm a bank today, I can't borrow money beyond a particular threshold. If I'm a bank today, I can't have change in shareholding unless with the approval of the Reserve Bank. Now, this regulatory structure is justified in the interests of protecting banks and in public interest. Now, if we're extending the same structure onto media organizations, there is a constitutional concern, like how much we won't like it. And the Supreme Court repeatedly emphasized, public interest is not a ground to restrict speech. So how do you want to, this tension is there, and how do you want to, I know if we had this regulatory structure, the NDTV Adani may have been stopped or could not, he couldn't have sold the shares. So are we really in favor of extending or putting media under a regulatory framework which could raise larger constitutional concerns of free speech?
Sure, sure. So maybe we'll ask the three panelists to respond. Okay, that will have to be the last question. Right, so yeah. No, in the afternoon panels, I think we'll have more time, so we'll open up the discussions. Yeah.
Adding on to what the others asked, when we talk about the model of regulatory framework to control, say, media ownership, so in that case, the way I look at it, wouldn't it be a two-edged sword where on the one hand, we are curbing your rights under Article 19(1)(g), but you're doing that, you're restricting that in favor of another fundamental right, which is your right to free speech and expression. So wouldn't that essentially be pitting one fundamental right against the other? And when we talk about Article 19(1)(g) and free speech and expression, if we are kind of curbing private bodies from restricting Article 19(1)(g) by controlling media houses, wouldn't that also raise questions regarding the horizontal application of fundamental rights?
I think that's exactly what the previous question was touching on. So I think we can have the three panelists respond, and let's maybe have an integrated response. Right.
Can I start? If you guys don't mind.
Okay, Alok, you can go first then. No problem. Yeah.
Sure. I think there was one specific question which was asked to me, which is what is the solution? And I think that solution has to do with the very rigorous way we have to reform how the trial courts and the district courts in this country work. And that starts in the way in which we recruit judges. Unfortunately, I know I have earned enemies in Nalsar for my views on how recruitment takes place for the district judiciary. But maybe examinations and interview are not the best way to do it. Not to say the process shouldn't be objective, but there should be beyond just your marks and your ability to impress in an interview. Second, I think the high courts, and at least in the context of the trial judiciary, they should bring their HR practices. At the end of the day, you're not controlling the trial courts and the district judges. You are at the end of the day enabling them to do their work and making sure that they do their work in accordance with the law. And that requires a certain kind of mindset and a certain kind of framework to understand how HR practices should be carried out. And I'll give you a very simple example. It's an anecdote which was told to me by a Supreme Court judge, which to me revealed a lot about the way our high courts and district judiciary function. This particular Supreme Court judge, when he was the High Court of, when he was a judge of the High Court, he was portfolio judge of a particular district, and they had recently appointed somebody to that as a district judge there, who had an impeccable record as a prosecutor. Right, you couldn't raise questions about this person's integrity or their ability in any way. Going through their very first annual confidential report, looking through the judgments of this judge, freshly minted into the judiciary, this High Court judge finds that 30 of the last 30 cases have resulted in acquittal. So he asks him to come to the state capital he doesn't issue like a formal notice, but says, please explain how is it that 30 out of the last 30 cases you have handled have ended in acquittal. And this district judge very humbly says, my lords, I was a prosecutor. I know how convictions are obtained in this country. In good conscience, as a district judge, I could not uphold these convictions. I simply cannot believe all of this. So obviously the High Court judge says, yes, you're right. Please continue. But flip it around. Would this High Court judge have called the district judge if he had delivered 30 out of 30 convictions? He would have said, wonderful, must be very honest, must be very straightforward, believes the state's narrative all the time. If there is something wrong in the law, we at the High Court, in our infinite wisdom, 30 years down the line, will figure out what is wrong with the law. But it kind of, there was no sense of understanding of what impact something like this happens on the psyche of the judge, their incentives, their motivations, and their morale at the end of the day. So I think we have to take this element of the HR practices of our High Court, to put it very starkly, far more seriously than just saying, oh, the High Court will take care of it and good luck to the district judges who try to stand out in any particular way. I'll make three very particular points for all the other 6 questions. I think, Mr. Vivek Reddy, I think we are all kind of agreed that a regulatory framework by the state, in my view, will be futile, because I feel that media houses and corporate houses will easily find a way around it. And number 2, let me just draw this one comparison for why the banking sector. The banking sector is per se conservative. The person who becomes a banker in this country is per se conservative in their outlook, forget about their social life or whatever. But in terms of how they kind of handle money and deal with the economy, they're per se conservative. For them, following rules is their life. So when the RBI prescribes something, RBI is fairly confident this will be followed. There will be exceptions. There will be people who look for basic. But I believe the media sector, and with no disrespect to my colleagues and friends who are sitting there, you're not somebody who believes that I should strictly follow whatever the government tells me to do. And you're successful in your field because you're not somebody who easily accepts authority so readily. So, not to say that they try to do something illegal, but I also feel it's in the nature of that industry that you will believe that, yes, the rules are all very nice, but I will continue to push. And I think we have to encourage our media to say push back against the rules. So I'm in full agreement that a regulatory framework will not work for the media, and it may not be the best, even something legally imposed in that way. State ownership of media is a good point, but I think that it's kind of becoming irrelevant as a as a point, because yes, people may listen to it for some factual updates, for weather reports and so on, but whether they buy into that narrative, I strongly disbelieve that. I actually believe that we don't give enough credit to people in rural areas in this country for the multiple sources of their news. Every time an election takes place, some reporter from an urban area goes to the remote rural area and is shocked to find out how politically aware everyone in the village is, even though they may not have 24-hour electricity. So I wouldn't underestimate the sources of news that people in rural areas get. And I'm not so sure that state ownership really serves the purpose of the state also, beyond putting out some standard warnings and standard pieces of news. I don't know if it really helps them, because that state broadcasters don't attract the kind of talent which is necessary to build the kind of effective narrative. There's a reason why Arnab works for Republic Now and not DD News, if he's such an important integral element to spreading the government's narrative. And employment contracts, I think we have to rethink a lot of our underlying principles of how labor and employment law works. I think we are applying frameworks which were great in the industrial age, which had a certain specific understanding of employment. We are seeing that happen with gig economy. I feel the future is gigification, so to speak, of the entire economy. I don't know how we will respond to it legally, but I wouldn't assume that putting in a framework which evolved in the industrial era, which worked well in the industrial era, is going to work going forward. I'll stop there. Thank you.
So I think, Alok, you should possibly consider joining us as a teacher with the efficiency in which you responded to most of the questions. But we'll now move on to the other speakers. So who would like to answer first? Apurva? Right.
So the couple of divergent views with Alok here, one on state broadcasters. The data shows us that 61% of those who own TVs watch television news. Digital penetration is not rising at the scale that we saw in the last decade. Given that we all consume news on different platforms, right? I necessarily don't just read newspapers anymore. I also get news on YouTube. I also get, I also read a newspaper, and I also watch television news. There's a convergence in the mediums of, how we consume news. So given all of that, the role of the state broadcaster can't be completely cast aside. There is still a large segment of, like you said, the rural population where this is still very, very relevant. And we've seen this, especially educators have seen this during COVID time, that there were about 20 odd channels which were used suddenly for teaching, right? You had third standard curriculums being taught on Doordarshan, and that was the only mode of teaching for a lot of people in India during the pandemic. So that is one of the reasons why I said that, public broadcasters need to be strengthened. Lok Sabha and Rajya Sabha, TV, or any of these, right, can't completely be an instrument of state and entirely, and have that biased way of reporting. That's something that needs to change. On the other issue, you talked about balancing 19.1 with other rights. But when we talk about free speech, we also talk about editorial discretion. The right, that is also part of free speech. As an editor, how I want to present my views, how I want to manage my newsroom, and what are the plurality of views that I, as an editor, want to put across is also part of free speech. It's not only the right to know of the public, right? So the minute you have, especially in a private company, articles of association which govern what exactly plural views should mean and how you protect that, all of that practically becomes very untenable. The market forces are still the best way to regulate this. There is a reason why, how you really have in reality, how media pluralism works is, if I get fired for doing my job in one newspaper, I should have another avenue where I can go do the same kind of journalism, right? That is one way of how a journalist's rights are safeguarded. I can't have just one place where I can do good journalism and otherwise the market is inaccessible to me. That's not how it works in real time. The other one I wanted to talk about is there is actually work done by Abhijit Banerjee when it came to Delhi municipal elections. They did choose particular constituencies and told people 10 days before an election, 15 days before an election, what the legislators over there did. They sort of prepared a report card and said, this is what your legislator did. The structural problem in India is that often it's not the individual legislator of your constituency that matters. It is the larger political party and their themes that really matter in an election. But this study actually showed that it influenced the voters greatly. The winning margins changed, the winners changed, a lot of this with just people being given more information. So state broadcasters are very important in doing that, because when if you watch Doordarshan this year during the run up to the election, you will see that the government has only done excellent job, right? Like every scheme has worked, everything has been delivered. There is last mile connectivity. Every beneficiary, every Labharthi has gotten what they deserve. That's where how you influence the voter in an election year really matters. So I hope that answers a couple of questions that we've mixed together the answers to that, but I hope that answers.
Yeah, I think I'll also, I will say that, one other aspect which you have to consider when you're looking at state broadcasters, and why there's a need to ensure that they are actually functioning properly, is what they broadcast can be used by other people. Like at the end of the day, what's broadcast on Lok Sabha TV, Rajya Sabha TV, that can be packaged by, that they now have a specific license, which they earlier you didn't used to have. But it's still it's a pretty easy thing to get. You have to then, you can put that on your YouTube channel, you can put that on any other TV channel, you can put that on your website. So if you don't have relevant things from, say, the opposition, or you don't have things on that broadcaster, then you will not be able to, even someone who's not the public broadcaster, who may not be having that much reach in a particular place, even the people who do have reach are not able to put that out there. So I think it becomes, it is an important question, I think, to think about how that will be implemented across the different matter. Like, we do want better, more balanced coverage. I think the idea of looking at the BBC standards was a great one. But again, can that really happen? Different issue. But it is something we should, in principle, be having. And I wouldn't argue that a lack, that the public broadcasters have lost that influence. I think the question which I want to pick up is this thing on how do you protect editorial independence? Other ways you can use. I think the question was, can you use employment contracts? Can you use other things? I think there are ideas to explore there, right? So, I talked very idealistically about unionization as one route. You've mentioned people's employment contracts. For instance, if you can have it that a person can't be fired for, doing, unless, there's clear misconduct, the ability to express a particular view can't allow them to that. You could try that, but of course, every employment contract, even the best employment contract in the world, will allow you to be fired after giving you, say, 2 months notice, purely on discretion. So as such, that wouldn't necessarily help. But the question is, are there ways to protect independence? Now, one interesting thing is, so I'm working now at a fact-checking company where we do work for certain clients as well, who are social media companies, right? So then technically, does that mean we are not allowed, on paper, that would affect our editorial independence to fact check something about the social media platform? But one of the things which protects us there is that we actually, one of the reasons why we even have those contracts with them is because of IFCN certification. Now, this is, of course, an international issue rather than a domestic thing. But for instance, the IFCN certification requires you to have editorial independence. So for instance, if you're working for a client who's trying to push you with that, you can go back to them and say, but I'm following the principles that you have required me to sign already, and it's part of our commercial contract as well. So therefore, it's okay. But that's a totally different ballgame when it comes to obviously news and when you're trying to deal with the government. Again, maybe one route is an independent regulator having the ability to examine these kind of decisions. Like say Ofcom in the UK does this to an extent, but again, it's not great. It's not a great system. We could try to build something on those lines here, but I think honestly, I think really one, I do also have some disagreements with what Alok said about a couple of other points, but I think he was absolutely spot on about the point that until you fix rule of law, you will not fix this problem. And these two things are intrinsically tied up. And interestingly, I mean, the EU regulations on this, in fact, reflect that. They have a media pluralism monitor, and that fits within their, and all the details on media pluralism and stuff come within their yearly rule of law report. I mean, this is an idea that is, honestly, if you want to fix that, that's where you have to go. And that means fixing judicial aspects at every level to start with, and also building an awareness among people of the need for rule of law, right? Like, how many people do we know who really understand or care about that concept outside of people who are lawyers or outside of people who are, academics or activists? Most people, and that's not, I mean, and that's not to say that, oh my God, these people are so silly, why are they not doing it? But the point is, and this is a place where the media needs to do better. It's, I think, where universities need to do better, because we don't do that enough for people. And again, of course, this is where, but this is, we're at a chicken and egg thing, because media pluralism would help you do that, but we don't have that yet. So that's.
Okay. I mean, ordinarily we would have carried on with the discussion, but as an organizer, I have to worry about time. So I thank Apurva and Vakasha for making the physical trip here and coming and spending time with us. Alok, of course, we do get him very often. So I think this time we'll give you a free pass. But thank you all for joining this discussion. And for the next one, we have to be on time because there is Dr. Osama Siddiq and Kumar who are joining us from abroad. And we do need to come back on time to ensure that discussion starts. But in the afternoon panels, we have budgeted for more time. So there will hopefully be more space for open-ended discussion in the latter two panels today. So there's a lunch arrangement outside. Please join us for the lunch arrangement. But then within 25 minutes, we'll be chasing you to come back. Right. Thank you very much. Okay. Kumar, if you've logged in, we can just do a sound check. You'll have to unmute yourself so that we can just do a sound check, Kumar. We can see you. Yeah, Kumar, can you hear me? Kumar, Mr. Guruparan, can you hear me? Yeah. No, I'm speaking right into the screen. He should be able to. I'm not sure. No, we'll have to ask him. Hmm. Okay, Kumar, can you hear me? We need to do a sound check with you. We can see you that you're in the meeting. Yeah. Yeah, or just call from the WhatsApp number. So they'll do it. They'll do it. Let them get into the meeting first. So Kumar is logged in, but I'm not sure if he can hear us. And Osama Siddiqui, I think we have to follow up to get him in the meeting. Okay, Kumar, you have to unmute yourself. Can you confirm if you can hear us?
Yeah, I can hear you.
Oh, excellent, excellent. So can we just do a video test also?
Yeah.
Right, right. We can see you in the hall. Yeah, good to see you. Right.
All
So
right,
we're
same
just
here.
trying to get Mr. Professor Osama Siddiq to also join. As soon as he joins, we'll start.
All right, sir.
Right. Thanks.
Thank you. Thanks.
Yeah. So. Okay, fine. We'll wait a couple of minutes. Okay. So I think Arvind will have to take over. Kumar is logged in. We're just waiting for Osama Siddiq to log in, and then we can start in a couple of minutes. There's the man. These mics also work. We're just waiting for the. You can, but I think for the speech, it will be better if you speak from here because you're also trying to create from the canvas here. So Kumar, are you in Sri Lanka or are you in England? We are not sure.
I'm in Sri Lanka.
Oh, excellent, excellent. Right. So hopefully we'll plan this in advance next year so that we can get you here.
Would be a pleasure, Siddharth.
Right.
Siddharth, it's Guru, not Kumar.
Okay, fine. I'll call you Guru. No problem.
Okay,
So
all right.
Arvind, he's insisting that we call him Guru. Right. Great. I've
Not
shared
that
that with
happens to
Arvind.
me.
I think you can see Arvind on the screen. He'll be
Yes, I can.
moderating. Yeah, he can see you on the screen.
Excellent.
And
All
we
right.
have Vivek Reddy, who's a senior advocate here in the High Court of Telangana. He's also a speaker in this panel. Professor Osama Siddiqui is just logging in. I think he had some troubles with WebEx. Dr. Sara Hussain, I think, has some other obligations. So we may have to skip her in this panel.
Yes, I saw that email from her. Yes.
Right. So just give us a couple of minutes to get Dr. Siddiq
No,
in.
no problem. No problem.
Right. Yes. Can you hear me, Professor Siddiq? Can you hear us? Right. Professor Siddiq, if you can hear us, can we just do one video audio test with you? If you could just turn on your camera, start video and say something. There's a menu just below your screen in WebEx where you can start a video, unmute yourself. You're already in the meeting. We can see you. Okay, so we are audio. You can leave the meeting and try rejoining. Right. Can you hear me, Professor Siddiq? Can you hear me? We are trying to get through to you. Right. He can hear. You can hear us. Excellent. So you'll have to unmute yourself. There is an unmute button. He is unmuted. That's right. Okay, this is everybody's using different platforms. So yeah. Right. He's unmuted. He's unmuted. Yeah. He's unmuted. Right. He's unmuted. Yeah. Okay. Yeah.
Hello. So could you just leave the app, leave the meeting from the app, just join the meeting. Yeah, just press on the link, and it should give you an option to join through the web.
It's fine. It's fine. No problem. I mean, all of us have had this issue. So right. No, it's Kumar only. Yeah. Right. think we should have done a trial. Not use WebEx again.
It's better to use the web so that the web will only have permission to use web camera and this.
Just from the email, just click on the link and then it gives you the option. Yeah, he's joined again. Yeah.
Will you speak now, sir? We can see you, but just speak now. Yeah, sure. Just
Right, so we can see you in the meeting. Could you just speak? All panelists are allowed to speak here. Yeah. Yeah. No, he has to do it. No, not from our side. Yeah. He can apparently hear us. It's the audio setting on his part which seems to be the problem. Because we were on touch over the phone. Yeah. Okay. 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 Yeah, I think we'll just then start then. Yeah, because otherwise we're losing time. We asked him, he's tried it twice. Yeah, 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 yeah. No, I think he used the WebEx. Yeah, yeah. I think he used the app first, then we asked him to log in through the internet.
select another option.
Or we can just use the phone to get an audio feed.
You just directly No.
No, we are okay.
Yeah. No, it's in that mic arrow button, please. Audio, yes.
Google Meet. Google Meet. Yeah.
The window. Yes, sir. He said mute button but arrow button.
No, he's unmuted. As for settings.
Arrow symbol is there, no, sir. Before we said that mute. Not a picture, sir. That mic symbol. Mic symbol. Yes, sir. That symbol. We just want to do the just set it up.
Yeah.
Yeah, mute only, sir. Mute.
Yeah, wait. This guy.
And don't press the mute, sir. Don't press the mute. It's an arrow, sir. Use it. Use it.
Sir, are you more comfortable with Google Meet? We'll just start a Google Meet. That will be easier. No, you're already 20 minutes behind. So I'll just open another menu or we have the email IDs. Google Meet. Okay, just tell Kumar also. Just tell Kumar also. Yeah. Kumar, it seems Professor Osama Siddiq is having trouble with WebEx. So we are sending you a Google Meet link as well. Sorry, Guru. We are sending you a Google Meet link as well. That's easier to join.
Do you want me to also join on that, Siddharth?
Yeah, because he's having trouble logging in. So we'll just do a Google Meet meeting because there's 2 of you online and 2 people are here in person. So we're just sending you a Google Meet link.
Great. By email, right?
Yeah. Yes, on your email ID. It's in the course and constitution column. Just look at the ID. It's simple. RK. gmail.com. Osama Siddiq is on the same thread. No, it's on the deal.
DR.
DR dot.
OSAMA.
Siddiqui.
SIDDRE at gmail.com. Check the names.
Make sure the spelling is correct.
Is it correct?
Osama Siddiq.
Can you send it to me also?
Hang on. Osama Siddiq. Double T. That's correct.
Yeah.
QUE. Keep it. Just send it. No, it's come. Just send the email.
This calls are up.
Okay, we've just sent the Google Meet link. Once you can join, we'll start there. Yeah, we have a login here.
Recording again.
The IT support is already logged in.
YouTube. Yeah, this is.
Hello, hello, check. Hello, hello. వస్తున్నాయి కదా? But we also have to look on because the problem is it doesn't matter if it's physical or online. It's with your speaker mixer. So we'll just look at it once. Okay. Hello. Hello, hello. హలో హలో కొంచెం సౌండ్ మంచి సౌండ్ వస్తుందా హలో తక్కువ వస్తుంది కొంచెం ఇక్కడ పాలు కూడా తక్కువ వస్తున్నాయి కొంచెం పెంచండి హలో 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 సరే వదిలేండి వస్తుంది వస్తుంది ఈయన ఏం చేయాలి మనం ఎక్స్పెల్ చేయలేము ఉన్నారు
Mohan Gopal. So I'll just invite Malvika to take over and moderate the flow of discussion.
Thank you, Siddharth. Good afternoon, everyone. Thank you very much for being here. Welcome to the panel. It is titled Affirmative Action, Changing Conceptions of Equality. As I understand it, the panel is going to unfold not only by addressing the changing conceptions of equality, which are kind of subject to the tides of what happens in the judiciary, but also it's going to be an excavation of the constitutional conceptions of equality as well, which may or may not have found recognition in the judiciary so far. So without further ado, I will invite our first speaker, Professor Dr. Afroz Alam. Professor Alam is currently serving as the professor and head at Department of Political Science at Maulana Azad National Urdu University, Hyderabad. His research has spanned contemporary and comparative politics, election studies, multiculturalism, and minority rights. Professor Alam, I invite you to open the conversation for us. You're welcome to, that mic works, so you're welcome to also speak from there if that's more comfortable. Okay. Professor Alam.
A very good evening to each one of you. And I am honored to be here today as a panelist to discuss the topics of affirmative action and new aspirational groups in India. I would also like to take a moment to acknowledge my fellow panelists, esteemed panelists, Professor Gopal and Professor Shankaran, and express my gratitude for the opportunity to be a panelist when both of them are the part of it. They are all expert in their respective fields, and I will be learning a lot from their insights on their topic. I'm an odd man out here because I'm not from legal discipline. So I have everything politics to offer. And without politics, the law will not be needed, because we need law to balance the politics. So here, I am here, I believe that there is a need for more nuanced and complex approach to affirmative action, and on that take into account the specific challenges faced by different communities, and that does not create unnecessary divisions. So as we understand that the affirmative action is a set of policies and practices that are designed to increase opportunities to historically disadvantaged groups. The aim of the affirmative action is to remedy the past discriminations and promote greater diversity and inclusion in areas of education, employment, and government contracting. And as we know that, in everyday classrooms, we experience the teachers who are coming out that the idea of equality is everything. And the whole moot point is that what is equality and are we really equal? Because here, whenever we talk about the affirmative actions, the assumptions are that there are unequal citizens amongst us who need special care. So traditionally, it was being thought that the idea of equality was assumed as that if everyone was given the same opportunities and treated in the same way, then discrimination would disappear and everyone would have an equal chance to succeed. That was the common assumptions earlier. But in my understanding, and we must understand that this form of equality will not help anyone else. It requires an active effort to level up the playing field and address the historical injustices. And this is where affirmative action comes in by actively seeking out and providing opportunities to historically disadvantaged groups. And you know that since I am the opening person and I am being asked to torture you for some 20 minutes, so let's engage into that. The point is that without having a theoretical understanding of the notion, we cannot proceed. And we have heard that affirmative action talks about some compensatory justice where we have to address the historical discriminations. Then somebody is talking about, no, we have to increase the diversity index. Let's every groups of people should be adequately represented. So we must have some policies regarding that. Some other group of people argue that the laws and the policies and the schemes should have some utilitarian value. Means that if we want to have a greater social and economic stability, then we have to reduce poverty. We have to reduce crime, we have to reduce social problems. And to achieve that, we need some affirmative measures into it. And the last the group of people argue that the democracy, that affirmative action is something right-based because, you know, it is needed. Why do we need that? Because everyone must be equally protected under the law. And it is the way to ensure that the historically marginalized groups are not unfairly disadvantaged. So because you know that in democracy, nothing is absolutely fair. So, and it is not a possibility as well. So what is possible that the fair compromises can be made. If not absolute fairness, then fair compromises can be offered. So in that particular context, I have my own propositions on affirmative actions. And let us bring the whole India into the picture. Because while being in India, and if you will not speak like an Indians, you are committing a crime. So fair enough. So while I understand that there are differing viewpoints on this topic on affirmative actions, I believe that and strongly believe that despite 7 decades of India's independence, many decades of affirmative policy measures like reservation as well, 3 decades of neoliberal reforms in India, a vast majority of the population, particularly a large section among the Dalit, Bahujan, Adivasi masses, and other socially and educationally backward and disadvantaged communities, still survive in precarious socio-economic conditions. Go them, visit them. And since we are having a good life, quite luxurious life, doesn't mean that everyone is having the same kind of life. So poverty, growing inflation, lack of employment opportunities, and the recent crises and tragedies like demonetization and the COVID pandemic have burdened the lives of the common people disproportionately and exponentially. So my argument is that in recent years, there has been a growing recognition in India that there is a need to move beyond traditional conceptions of equality and adopt a more nuanced and complex understanding of the ways in which different groups are disadvantaged and discriminated against. And this has led to the emergence of new theoretical paradigm that gives address to the changing framework of equality in India. And one key element to this new paradigm is the recognition of intersectionality. When I'm referring the whole idea of intersectionality, I'm using it in the sense that the idea that the people experience oppression and discrimination in different ways based on their intersectional identities such as race, gender, caste, religion, sexuality. This means that the policies and practices aimed at promoting equality must take into account the unique experiences and needs of different groups. You cannot make a generalization. So every community and groups have their own unique experiences and we have to take into account. Another important element is to emphasis on the social justice and redistribution questions. This means that recognizing that historical and ongoing inequalities have created deep-seated disparities in access to resources, opportunities, power, And addressing these disparities requires not just only equal treatment, but active efforts to redistribute resources and power to marginalized communities. And third element, my theoretical aspect is to that there is a need of recognition of the importance of cultural and linguistic diversity, diversity. And you know that India is a home to a vast array of cultures and languages, and efforts to promote equality must take into account unique needs and perspectives of the different community. And finally, this my paradigm emphasizes that there is a need for grassroots and community-led approaches to promoting equality. And rather than relying solely on top-down policies and programs, it recognizes the importance of empowering communities and individuals to take action and advocate for their own rights. Overall, so my whole question is, if I look back the empirical experiences in India, I have three explanations to offer so far as the movement of certain groups and communities for their rights or for their demands of having a special care from the state institution. The one is that there was a phase in India when we experienced that social fragmentation. So the idea was that the society was a unique whole, and there were efforts to fragment the societies into different identities, cross-cutting lines of the identities. Then the second phase came up when we saw that so many unique generalized categories emerged, that we are Dalits, we are OBCs, we are women. Right here, that the second phase I call it, that is called social defragmentation. You started defragmenting the communities into one identity. That, for example, Dalit is not only a single category. It is a composite of so many caste groups who are being treated as one category. Now we are into the third phase, and that phase is called social refragmentation. Now Dalit has to be further fragmented. You are no more Dalit. You are a Jata first and Dalit afterwards. Then the another caste, the individualized, that is called spatial differentiation within the groups are emerging now. And if you recall, there are almost 3,000 political parties in India. And what they are doing, they are into fragmenting the whole categories, the caste categories. You will find that there are around 136 Dalit-based parties. All you will find in their name, Ambedkarites, Bahujan politics, what they are doing. So the point is that there are new identities are being formed within the larger identities to assert and share in the past. So another idea, while arguing that so many political parties championing the individual caste categories, community categories, issue-based, now the refragmentation is taking place across. And here I argue that in this whole process, a new aspirational groups within scheduled caste, within scheduled tribes, within the gender categories, within region, within communities are emerging. And there are so many groups. So intersectionalities are there. And here that we call about secular sectarianism, that within these sectional groups, there are so many other groups who are emerging. Similarly, the second aspect which I am focusing on, that there are differentiated assertion of marginalized groups. I am more interested to assert my identity not as Muslim alone, but I will be asserting my identity as Pasmanda. So I am not only interested in asserting my Pasmanda identity, I will be more interested in asserting that a Pasmanda from an exclusive poorest region of Uttar Pradesh called Purvanchal. So I have the multiple aspect to assert myself. So there is now a differentiated assertion of the marginalized group. So one category will not be having any appeal on me. Similarly, there is a third aspect which I need to focus on, that extending the boundaries of social justice to private realm. So now that the public realm, so far as the social justice is concerned, started getting saturated. So we need to extend that the policies to the private realm so that larger number of people to get into the three aspects which I wanted to cover that. So now that let us analyze the recent approach into the context, theoretical context I have offered. The one is that how the current regime, that there is a regime in India who is now approaching to the new aspirational groups. If you will look at the representative character, if you will look at the diversity index, if you will look at accommodating the marginalized sections into the overall framework, you will find a master strategy from them. So in their ministry, you will find a Pasmanda. You will be that non-Yadavs are being approached in OBC categories. In the Dalit categories, the non-Jatos are being approached. So the one is called like that. And they are being highlighted that in overall scheme of social justice assertion, in the OBC categories, there are 300 caste categories who have never been represented at all in the parliament and the state legislature. What is going to happen with them? Similarly, in the SC categories, there are almost 400 caste categories who have never touched the assembly and anything. So do they not having? So these are some questions and recently we have seen, and I'm quite happy that Professor Mohan Gopal is sitting here, who has argued the case in the court on the EWS category. That article, that 103rd amendment is being made. What is the whole task? Here, that the current regime tried to appropriate the aspiration of the poorest groups among the upper caste and make use of it for their electoral advantages. And the Supreme Court, you have seen the judgments, they are saying that the reservations for the poor section does not harm the basic structure of the constitution. I know that the law is all a matter of interpretations. And whether the ruling party is interested in your representation, then that interpretation becomes the ruling interpretations. So fair enough. You have also seen that the new regime is trying to reach out to the Muslim, a party who is otherwise known as creating narratives against the minorities, now coming out with Isneh Yatras. Isneh Yatras to accommodate the Pasmandas and other categories. Yeah, you see that in the larger minority appeasement, who were the beneficiaries? The Ashrafiyas were the beneficiaries, and the poorest sections were being ignored by the Congress and other social justice parties. Imagine the situation. Now that they're reaching out to the Dalits, so what they have done, that they have created a way out of doing that sadhavis, that OBC sadhavis and Dalit sadhavis, and the increase of jagarans in the areas which are heavily located by the Dalits are now the new strategy. Similarly, that the third phase I am experiencing, the Labharti model. You can see that what is that? Each and every policy of the government is now addressing the non-dominant Dalits and OBC categories. Well, for example, Shauchale, who will be the beneficiary of the Shauchale? I was doing a survey in one of the elections. I usually do. And then said that one woman respondent was there and the husband was sitting. Who are you going to vote? So he said, no, it is going to be BSP. The husband was responding on behalf of his wife. Then after some time, I just started leaving and the husband went to his own work. Then that woman called me, see, I'm not going to vote BSP. I will be voting for Modi ji. Modi ji? Why didn't you speak before that, your husband? He's saying that, no, Modi ji has given us Shauchale. So see, imagine that she has to go out for all that is natural needs, and suddenly she asked me that imagine that the party is reaching out to the subconscious of the electorates. You need that how the strategy is working out. Similarly, the gas cylinder, you people have no issues with gas cylinder because you have never cooked. So in the kitchen, who will know the pain of a kitchen? The woman will understand. The gas cylinder is having symbolic value. That person is able to finish it. But see the smart strategies. Smart strategies is now that one India, one party, one religion is all about that one Shamshan for everyone. Earlier, the whole questions. Now Ambedkar is being asked to sit with Lord Rama. So they see the level of compromise. My whole worry is whether those compromises are because of the electoral incentives, whether electoral incentive can be an explainer for the change of heart of Hirday Samrat. That I am not aware of that. So, but affirmative actions are into the pictures to accommodate those who were otherwise neglected by the so-called social justice-based parties. Imagine a situation, it requires gut that a tribal president was being asked, that a tribal candidate was being preferred over the political juggernaut of other categories for presidentship. Similarly, that a Marathi was being picked up over a North Indian that is Brahmin in Bombay. Some symbolic symbolism is there. if the opposition is not able to understand that something is missing in their narratives, in their strategies, then they will not be able to come up with their own policies. They have to say no to their feudal approaches, which are otherwise not there. Similarly, the answer lies in there. But my point is that tomorrow in one of the discussions, they were saying that they are going to rethink over their strategies on introducing reservation in private realms. Do you have an answer? Of course, yes, because the many people see that. Do we need that reservations in the private realm? Yes, my answer is absolutely yes. But some people, and even on the way, Akhil was there asking so many questions that why do we need and hey. So the point is that we need to assess that what we have achieved, what we aim to achieve in the public sector with that reservation, what we have achieved so far and what are left to achieve. But we cannot have data if we are not having the full empirical data before us. I personally feel that the caste census data should be released. The NSSOs and all other organizations who are into the measurements of social development should come out with the data and then say that, yes, the reservation has done this much of good. So we need to assess the aggregate outcome in terms of socio-educational progression of the marginalized groups and accordingly devise more strong measures to overcome the gaps to empower the communities. And my whole position is let the incentive of the reservation percolate down to that group family among Dalits and OBCs who could not get the benefit of the reservations for any reasons. But here, the reservations which are otherwise being critiqued is not for some thing like poverty alleviation program. It was being introduced to make certain communities at par with the mainstream communities. Certain historical factors are involved, certain diversity element is involved, certain representation questions are involved, certain non-dominance criteria is being involved. You cannot say that, yes, reservation is being offered. My whole worry is that some people offer that, yeah, the affirmative action for the marginalized sections is completely spoiling the chances of the meritorious, efficient, competitive categories belonging to one particular caste dominant groups. My whole worry is that why can't we demand that the 50% non-reserved categories, let the government disclose the data. Who are the people in that 50% non-reserved categories? So if the domain is that if 95% people belong to the one dominant caste group in open categories, it means that the Dalits, the Bahujans, the others cannot be meritorious at all. They cannot be efficient because in the name of merit, you have 50% reservations. So the idea is that we must have the data first, then we argue. So we can only argue in terms of suppositions, propositions, opinions, but we cannot have a policy measures without having a concrete data before us. So my whole worry is that we need to extend the whole affirmative action measures to all those groups now that the public sector is now over. Because all the companies are getting privatized. Most of the workforce are organized in informal sector, unorganized sector. So the point is that we need to, if the affirmative action is good in public sector, it is equally good in private sector for the same reasons. So we need to extend the benefit of the social justice, affirmative action in the private realm. But that should not be done overnight without a thought. We must have a data to establish the need and to go ahead with that. So that if we are having that data, so this measures will not only provide guaranteed employment, but also reduce the possibility of the hostile rejection at the end of the private employers in the name of merit, efficiency, competitiveness, capabilities. This is what my argument in the overall, because that we need the affirmative actions, and this is what it is good for everyone, because those who are neglected and deprived and disadvantaged are not from alien. They're not aliens. They're not from Mars. They're our people. So we need to address their injustices. We need to make them at par with them. And it is not a charity, it's a matter of entitlement and rights. So we know that I was quite happy that in the universities are laboratories where the revolutions happen. And I see that there are certain sections, the contract employees are there whose voices are being raised by the student. You know that there is only hope are left from the student. There is still, that is, their minds are open. They look at the question of redistribution and recognitions. And I appreciate those who are raising the concern. Doesn't mean that it will be solved and resolved immediately. But raising the questions are important. So somebody should raise the questions. Let us not lose the case in the idea of victimhood where your minds are paralyzed. No, you should give a sense that you are alive, that there you have a soul, and in that soul there is some हरकत. उस आपकी जिंदगी में, और मैं कहता हूं that कि the social revolutions do not happen in the realm of ideas alone. When you translate that ideas into actions without expecting that the results will come, only then it will go out. Salute to those people who are into this. The administrations have their own problems, but at least some bridges are to be made. And at the end of it, thank you for your attention. And I would be happy to answer any questions you may have at the end of it, whenever the moderator allows. Thank you, everyone.
Thank you very, very much, Professor Alam. I will hand over the floor to Professor Kamala Shankaran. Professor Shankaran is currently teaching at the National Law School, India University in Bangalore, and she's the Ford Foundation Chair in Public Interest Law at that university. Prior to this, she taught for many years in the Delhi University. Her interests are in informal economy, constitutional law, and labor law. Professor Shankaran.
Thank you very much. And thanks to Siddharth too for this invitation. And so both Professor Gopal and Professor Alam. So mindful of the fact that Professor Gopal is here and he's going to follow me and be the next speaker, I'm going to restrict my comments in a limited way to certain angles of the Janhit judgment, but locate it in a more broader context, I hope. Okay. So closer to me. Okay. So if we look back, okay, so this is all Amrit, a year of the Amrit, we are 75 years, and we look back, you look at our constitution, the question of addressing economic disadvantage has been a central one, I think, these past 75 years. It's not as if it became center stage in the 103rd. It's been center stage. And if you look at our constitution and you look at the toolbox that our constitution created, it had part 3, part 4, but if you look closer at the toolbox, they had affirmative action. And by that I mean that you have regular special measures for predetermined groups. But it also had a proactive state that was expected to do various things for various groups. And they were identified fairly clearly in part 4, but also implicitly in part 3, right? Address people in need of want, social assistance, maternity benefit, legal aid, you name it. Of course, legal aid came a little later, but it was there. Minorities and what was to be done with them, special provisions was there. So the toolkit was very, very well equipped to deal with economic disadvantage and other kinds of deprivation. So if we were to just leave India for a moment and you look, say, to the United States, and you look at the kind of litigation that's happened in the American Supreme Court, for example, looking at affirmative action, the absence of a provision such as express provision in ours has led those judgments to examine more closely the moral justification about why government policies cannot be even-handed. that it would lead to what Nancy Fraser calls misrecognition, that it would lead to maldistribution. And therefore, a lot of their reasoning is why the government needs to intervene. Now, if you look at the judgment in Ashok Kumar Thakur, the judges say that because we have a provision and our constitution is so well equipped with the toolkits that we have, we don't need to justify why we have affirmative action. And so the judges went on to declare that strict scrutiny is not required to decide the validity of the 93rd constitutional amendment. Remember, it's the one that introduced Article 15.5. No need for strict scrutiny, which, as students of law, we know means that the court will examine what were the other alternatives available. And has it taken, in one sense, the narrowest, the least socially expensive, the least state heavy option available? That's off the judicial, off the table. So Cass Sunstein says that if you look, having a constitution which takes deep political questions that have the tendency to tear society asunder. These are his words. If you were to have constitutional pre-commitments to things like affirmative action, you don't need to waste so much time to decide whether society should have it or not. So the example Cass Sunstein gives is that it resolves a prisoner's dilemma. Okay, it's from game theory that each of us doesn't know what our position should be. Society has already decided it. And that is the reason why, if I look now at the 2008 Ashok Kumar Thakur judgment, when it says that strict scrutiny is off. So what does the court then look at? It doesn't examine should there be, why there should be, but examines secondary questions like how should it be? Who is the beneficiary? How much should it be? It doesn't ask that macro question because it has been settled. So we have a constitution that is like that. But I think that this also has other consequences. So let me now move to the 103rd Amendment. What does it mean? In the toolkit that the government has, it always had a, Garibi Hatao and all its attendant policy measures that can flow. And these policy measures could take various forms. You give compensation if there are natural disasters. You could decide to give what we call social assistance, which is a form of social protection where whether you're employed or not, whether you've contributed or not, you're going to get something. There's a lot of outlay for that. The government can decide how many schools to build, how many universities to build. It's all what we as law students will think of as in the executive realm, the discretion of the government, where allocation can be done. Now, when the government exercises its executive policy to decide to do welfare measures, please remember that there is no judicial scrutiny over that. Once the appropriation bill has been passed, why this has so much money for arms? So the guns and butter debate is outside judicial scrutiny. Simply. Okay, it can decide what it wants to do. And the executive then has a free hand if it decides to go with welfare. So it can go up, it can go down, and 75 years has seen a great deal of this happening. Now, what are we saying? Because of severe crisis that is happening, a social crisis that is happening, we say that addressing economic disadvantage is going to come through the affirmative action route. It's moving away from the welfare to the affirmative action option, both of which are part of the toolkit. Okay, so it's like this Hindu goddess with many arms. That's the Indian state for you. It has many options before it. It has chosen now to go down the affirmative action path. But remember one thing, that a lot of our anti-poverty measures have been welfare, poverty alleviation. In fact, a couple of the judges' arguments were made by counsel that affirmative action is not an anti-poverty alleviation measure. It belongs to another bucket. Now, what you find is that if it's social assistance, it's usually universal, it's not usually targeted. It's open-ended. Take, for example, Manrega. Anybody can go and work. You self-select yourself. There's no question of a quota. There's no community. You can go there and do it. Now, the government has always had the option in front of it to upscale and scale up its anti-poverty measures. It has not done that. It has instead decided to do the 103rd amendment. And that it has many consequences. So I'm not going actually into the nuts and bolts of the judgment. I'm wanting to step back and look at it from a little further distance away. Parliamentary oversight for allocation of anti-poverty measures, welfare measures. Judicial scrutiny when you have an affirmative action program. An affirmative action program, which is, remember that there also degrees are different. I don't have time to go into it, but the degrees of scrutiny for SC and ST selection is far lower than the judicial scrutiny for SCBC identification, right? You need a commission and the court will jump full tilt into it. If time permits, I'm going to take up a Telangana High Court at that time, Andhra Pradesh High Court decision. Let me see if I have time. So the other aspect of the universal rights and the government policy is that it doesn't have what Amartya Sen says, the coherence of rights. It's a question of your benefit. There is no duty bearer that you identify, and therefore the government may give, it may also not give. Now here, this is the setting where we have the 103rd constitutional amendment. But in the meanwhile, there's also another development happening, which I think we should keep in mind. What has been welfare is increasingly, because of our PILs, also getting transformed from government benevolence to socio-economic rights. So over the 75 years, what was earlier an affirmative action versus welfare is now affirmative action versus socio-economic rights. And there are implications of this too, because a lot of right to education, right to housing, right to medical care has been partly made justiciable, which the earlier welfare regime was not there. Now, look at the choice that the government did have at this point in time. It could have, as I'm arguing, could have decided to up the welfare measures, up the socio-economic right, which would have made it accountable in the political realm to the people, or it could have chosen to make more rights-based legislation for socioeconomic rights. It's at that critical juncture that they have moved the 103rd Amendment. And one of the aspects of the 103rd Amendment, as it has now been approved by the court, is that it looks like it has increased the scope of scrutiny by the judiciary. But because strict scrutiny is off the table, we have never asked that question in Janhit. Could the government not have done something else from its welfare route to have addressed economic disadvantage? And why was affirmative action the option of choice? Why can we not ask it? Because Ashok Kumar Thakur tells us that we don't examine why you do it. We just look at that amendment and see how it is. You don't go into the deeper governance issue and the choices that the government had, which I think the Indian government is very well protected under the way in which the constitution has been framed. Now, somebody could argue, if strict scrutiny is off the table, we're dealing with an amendment, and an amendment doesn't do normal legal review, right? Which is to test the proportionality. We don't look at that. We are looking at the basic structure test, the width test, the identity test, you know, in my personal opinion, has been fleshed out well by the courts. It's the width test, which is so, you know, it's done so in 3 sentences in M. Nagaraj, and you can make of it what you will. Okay. So, and in fact, I found that Even Justice Bhatt, in his dissent in Janhit, identifies the identity test as the test. He, somewhere, wit fell off by somewhere. Okay. So you could argue that strict scrutiny is irrelevant, but the point is that it has gone off the judicial table. Let me now move to another point about the 103rd. So my first point was there were other choices without going to affirmative action. It's a deeply political decision, and the courts, by not examining were other alternatives available, have also post the no strict scrutiny. Now, the second point is, I want you to look at the difference between 15.5 and 16.5. Sorry, 15.5 and 15.6. Remember, the 15.5 was introduced by the 93rd Constitutional Amendment. And what does it say? Just permit me to just read out just this. It says whatever it says. And then it says, nothing in this article or in subclause G of Article 1 of Article 19 shall prevent the state from making any special provisions for advancement of socially backward classes, etc., in admission in private educational institution. But they also say nothing shall prevent the state from making any special provision by law. So any special provision for SCBC in private educational institutions need the law route. So you've looked at Modern Dental College, okay, the private Adhiniyam of Madhya Pradesh. There's a law. You need a law. And why do I need a law? Because TMAPI has said setting up an educational institution is an occupation under 19(1)G. And if it is an occupation, Article 19(1) tells us there's no way you infringe a 19 liberty unless it's backed by law. So it needs parliament. This is the first time that reservation has been introduced by law by the 93rd. I taught for the longest time in Delhi University. There is a Central Educational Institution Reservation of Seats Act, which came immediately after the 93rd Amendment. Till then, we had M.R. Balaji to support us. M.R. Balaji, Justice Gajendra Gadkar, had declared that 15 is enabling. Government may give, it may not give. It's a pure executive act. There's no need for parliament to get into it. It's the core of 73 that we were talking about, Malvika, the other day. You need a law, and we do have a law, okay? Now comes Article 16.5. Same thing, 10% reservation in all educational institutions, including private educational institutions. Look at the wording. It tells in 15.6, nothing in this article or subclause G of Article 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of economically weaker sections. You can introduce 10% reservation by government executive directive. There's no need to go for a law. They've taken away even that legislation, the need to go and stand in front of parliament. It's not been touched on at all in the Janhit judgment. Why there is this asymmetry between 15.5 and 16.5, but I have a reason why it's there, and let me suggest it to you. When Ashok Kumar Thakur was being decided, if you look at Justice Dalveed Bhandari's judgment, he said, should I decide the constitutionality of it vis-a-vis private educational institutions? Because this is a moot question. It's a hypothetical. Because there's no private educational institution in front of us. And from 2005 till now, nobody ever came before the court. They did not want to shake any boat. Okay, education is a space, private, autonomous, but you don't want to rub any government the wrong way by daring to challenge it. So they kept quiet. And I think it's because of that they decided to even drop the need for a law. So it's strengthened the executive so much in this particular way, because there's no way, we know, any private college can come up, but we know finally it is under the government's regulations. Anybody who's sitting here who knows anything about private educational sphere, you know Excuse me, it's a highly regulated space. And therefore, there is this. But they have made laws. They've made laws for other things. For example, you know, Professor Afroz was talking about Sons of the Soil legislation that so many states have passed. Haryana has passed. Karnataka has passed, where even in private companies, you must take so many people with Sons of the Soil. So law is there. So, okay. So this is one of, let me turn now to the last aspect of Janhit that I want to touch on. So, you know, if you look at Professor Alker Foster, the two of them who have developed the multi-dimensional poverty index, which is now, of course, the backbone of the World Bank's MPI, they've made this discovery that numerical poverty is not good enough. We need multi-dimensional poverty. So, I mean, please excuse me, what's new in it? We discovered this in India years ago. When you want to define backward to M.R. Balaji, they told us that numerical poverty is nothing. Look at the four factors that Justice Gajendra Gadkar talked about: occupation, place of habitation, education. So it can never be pure poverty, right? It's always in multidimensional to decide backwardness. Okay, so sometimes you look at these things cynically and you say, oh, so didn't we always know it? Okay, but now in 15.5 and in 15.6 and 16.6, we've gone back to a numerical way to measure poverty. 8 lakhs, a flat, 1,000 square feet flat, 150. Excuse me, okay, so the asset, it's just that. That's when you look at EWS. But if you want to be a backward in those excluded categories now post the Janhil judgment, SC, ST, OBC, please note you will jump through many more hoops to show that you are backward. Because the conception of economic backwardness is thicker here if you belong to a category, and it's very thin if you don't belong. Why is it thicker here? Let me just take two quick examples. Go back to Mandal, 22 points, 3 points, 4 points for economic backwardness. You have to live in a pakka house. You should not have indebtedness. Okay. So it's not just numerical it's not just haath mein kitne paise hain. It's not like that. Whereas here it's only 8 lakhs. And that economic inequality indicates that you don't have the social capital to jump out of it. Okay, the social capital is linked. But now when you look at numerical, so there's this beautiful paragraph of Justice Jeevan Reddy in the Indrasani. And he says, imagine a scenario that there's a riot in the city and everybody gets destroyed. Everybody has zero income in their wallets. But the person who will spring back again is the one who has social capital, who has connections, etc. And therefore, there is a difference between numerical poverty in this side and that side of the divide. And therefore, what we now notice is that here, the thickness that is here, so this asymmetry post the judgment is deeply disturbing. That you have a numerical poverty and you have a far more, I'm using the World Bank phrase of a multidimensional poverty measure when it comes to the categories, but what I really mean that it's thicker. So let me now just conclude, because I think I'm running out of time, with my last quick point. What does this mean for us in India? One, there is a strengthening of the executive and its decision of what it needs to do. For example, now that the 103rd has been upheld, nobody can question what should be the criteria of economic. Should it be 8 lakhs, 10 lakhs? So they've put 8 lakhs so that creamy layer and this are equal. But this is a thicker one compared to this. Okay. There is also there is a modicum of judicial, but it doesn't operate where it really counts, because you cannot ask the government, why have you reduced the budgetary allocation to Manrega? Because that's all falling within the realm of welfare. So the only thing that you can look at is now something around this, okay? Because you've not been given this choice. It has a specific impact in other ways too. So let me just go back to Sachar committee report. If you go back to the Sachar committee report, since Professor Afroz raised this point, I think I should also add something to this. So in Andhra Pradesh, there was a 5-judge bench which held in 2003 or 4, I'm forgetting, T. Muralidhar Rao, that Muslims as a community, the government declared are backward. And the 5-judge bench said, no, 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 we need a commission. So commission was there. And the commission came up before the validity of the commission and its methodology and its findings came up before another 5-judge bench. For those of you interested, B. Archana Reddy versus State of Andhra Pradesh. And one of the key findings of that commission was that many of the rickshaw pullers, for example, in Hyderabad, I'm taking this example because I'm speaking here, okay, otherwise we could have taken something else, are Muslims, excuse me, and therefore they are backward. And the court says no. If a religion has to be backward, then you must combine, this is just poverty backwardness. It must have the whole bandwidth of social backwardness. That is, they must be doing an occupation which is perceived as socially backward by other people. You know, the perception tests which are there in Mandal. So this is an example. It becomes very difficult because for people who are SCBCs actually, to show that they are economically disadvantaged, they will have to prove much more compared to others. And therefore, by the court deciding to take off the table, judicial table, so many things, I think that this is giving a freer hand to the government to decide how it is going to allocate its budget resources. It can say, we've given you EWS, so we are going to use our budget now for other things because we've addressed it there. In any case, this has been happening. India is an extremely poor country. Budgetary allocations have been, some cases have been falling, not all cases. I must be correct in what I say. But the ability of judicial scrutiny over this has already been taken away. And therefore, I think what we are seeing in the times to come is that the degree and careful scrutiny that we need to see that anti-poverty measures are done and that this should be seen by people in a way that there should be accountability, I think has come under grave threat. Thank you.
Thank you, Professor Shankaran. I will now invite Professor Dr. Mohan Gopal to offer his remarks. Professor Gopal served as the director of the National Judicial Academy of the Supreme Court of India for 5 years between 2006 and 11. He's also the Vice Chancellor of the National Law School in Bangalore prior to that. Many of us have probably witnessed him opening arguments for the EWS case, Janhit Abhiyan, before the Supreme Court, probably on live law. Professor Gopal, without further ado, I welcome you to take the floor.
Thank you very much, Malavika. My warm greetings to my very distinguished fellow panelists, Professor Kamla Shankaran and Professor Adam. Thank you for this invitation, Professor Chauhan, and the privilege of being here. I'm delighted to be here. I've come here through the courtesy of Professor Ranbir Singh at the very beginning when this facility was very new. And I think it has really been remarkably well preserved, and it has really grown into a very lovely campus, very well designed and so on. And I'm sure it will be even more wonderful if the workers are given equal rights. and it will be more enjoyable. If not, I'm always available pro bono with no charges at all. Uh, I'm 69 years old. There's no need, no excuse for me to be anything but pro bono. And so I'm not saying everyone should be pro bono, but certainly if you're at my stage in life, when there is no excuse to be not pro bono, one should be pro bono. So I'm available if you wish to make this campus even nicer and than it is. But it's a wonderful campus and a great atmosphere. So thank you to be here. I'm going to, and I'm used to being asked how many hours do you want to speak on this, so it's a huge topic for me and it's very difficult to compress it. I very much appreciate the very interesting perspectives, as usual, given by Professor Alam and Professor Shankaran. Professor Alam looked at it from the point of view of different groups and how do we understand India? And I want to come to that. And Professor Shankaran asked us to think in new ways about the constitutionality, assessing the constitutionality of the 103rd Amendment Act, including by resort to the standard of strict scrutiny and so on. So that's also relevant. But I want to start by, there's no title here to the topic, but the title has the words affirmative action. So what I want to do is I want to request you to revisit some of the fundamental ideas on the basis of which we are approaching this topic. And one fundamental idea is affirmative action, right? And the other fundamental idea is reservation. And the third fundamental idea is why do we have 16.4, 15.4 discrimination? What is the rationale for that? And so this is the main thing which I would like to invite you to reconsider yourself. And I'll share some ideas with you on that. And then we'll come to what the implications are very briefly to understand the judgment in a different way. And we go forward. So it's now 5:23. So we have only 7 minutes left to our scheduled time. Sorry. Okay. And Malvika has kindly granted extra time to 6 o'clock. Professor Chauhan, having rejected my initial application to allow me to appear online, has also approved this request and has arranged with the Indigo Airlines to delay my flight so that I won't miss it. I have to go to Kochi from here. So let's say we'll go up to 6 o'clock and then we must have some Q&A. So we'll try to leave some time for that before that. So very quickly, almost telegraphically, I don't think we can call this affirmative action. I think those who are calling what is going on under 15.4 and 16.4 as affirmative action are borrowing it undoubtedly from United States usage of affirmative action. That's where this phrase comes from. And it shows to me an anti-reservation mindset. Why can't we call it reservation? Because we can't digest it. So we're looking for some other way which, sort of white people have used, civilized people have used, which must be a little bit legitimate because white people use it, must be okay. So we call it affirmative action because that's more kind of, upper crust than calling it reservation. But it's not affirmative action. If you look at, I would suggest you look at 2 books to understand why I'm saying this. One is a book by Professor John Carson of Michigan, where I first met Malavika when she was doing her LLM there, published in 2007, called The Measure of Merit. Measure of Merit. And the second, of course, much better known book is Sandel's Tyranny of Merit. But Measure of Merit is a little more relevant to us because Professor Carson, it's a massive book. He really goes into, he compares the struggle of the United States and France after they overthrew the aristocracy. I'll now quote from him just a few lines. He says, having toppled aristocratically organized societies in the name of natural rights and people sovereignty, United States and France struggled with the question, what would be put in their place? How could a new elite be selected and justified within a political ideology that also celebrates equality and human and universal rights? How do you reconcile elitism with equality? How, in other words, could inequality be rendered legitimate in such a society? Because aristocratic society rejected equality and accepted inequality. But after you overthrew the aristocracy, then you cannot reject equality, but you don't want to reject elitism itself, because the Americans and French people, the French system today, up to this day, accept the fact that human beings are not equal, that some are better than others, like they did during the aristocracy. It may be natural, it may be as a result of nurture, we don't know for sure, it may be a mixture, but not all human beings are similarly talented or qualified or capable. They accept the fact that there is difference in capacity between human beings. And that is the basis of elitism, because if that is accepted, you want the better humans to rule us and to lead us. And you want to sort out the less capable from the more capable. And so lack of time, otherwise I can read a little more from Carson. Basically, they came up with standardized testing, starting in France and bringing it in the US. You're all here because of standardized testing. Standardized testing has been completely rejected by now all over the world as not telling us anything about anyone. But it serves only one purpose, and that is legitimizing inequality. Because you're sitting here, many of people cannot sit here. That's inequality. They've been denied admission. How do you legitimize that? By saying you're better than them. And how do we know you're better than them? Because we've done standardized testing. Objective. And so they develop standardized testing, as Professor Carson says, to legitimize inequality and justify inequality, because they accepted elitism and rejected the proposition which was expressed on August 27th, 1947, in the Constituent Assembly, 12th day of independence, by two Dalit members of the Constituent Assembly, Mr. Muniswamy Pillai and Mr. Nagappa, both from the Madras British presidency, one from the Telugu speaking area, one from the Tamil speaking area. They said, in brief, to the assembly, the British have left, but there is fear in the minds of the scheduled castes. Whole country celebrating, the British has said. These gentlemen are telling the Constituent Assembly on the floor of the House on the record, please go to August 27, 1947, verbatim record, you will see these interventions by Nagappa and Muniswamy. They say, we have fear, we are afraid. Why? Because the Hindus are coming to power. This is their words, not my words. The Hindus are coming to power. In that day and age, only the upper caste was allowed to call itself Hindu. Caste Hindu, or Hindu meant upper caste. The others were outcasts. Outcast means out of caste. Now they're accused of being casteist. All the centuries they were told you're out of caste. So I don't know how outcasts can be casteist. Only Savarnas can be casteist because only they had caste. But now they are not casteist. They are meritorious people. And the Avarnas are casteist people, although they were denied caste for all these years. So they said the Hindus are coming back to power. Will they bring back Hindu Rashtra, Hindu Raj? Will they revive Varnashrama Dharma to harass the Harijans? Nagappa said, we may be dumb, totally opposing the approach of the Americans and the French. He said, we may be dumb, we may be illiterate, but do not take advantage of our dumbness and illiteracy to deny us our due share, to deny us our humanity. We want in this country our due share. In other words, they were saying, we do not want an elitist society in this country. We want representation. This was not new. In 1931, first roundtable conference, must be part of this teaching of constitutional law, must begin with this document, in my view. It is almost, to my knowledge, never included in a constitutional law course, to my knowledge, in our country, which is a document presented by Dr. B.R. Ambedkar to the first roundtable conference, which was a memorandum setting out 8 safeguards or conditions on behalf of the depressed classes. In his speech, Dr. Ambedkar says that we are here. Good evening, sir. Very nice to see you. Yes, sir. In his speech, Dr. Ambedkar says, we are here, I'm here with a mandate. One part of that mandate is to demand responsible government. And that was the universal demand from India by everyone. We want responsible government, means government responsible to the people of the country. And the British did not reject that. They believed in trickle-down responsiveness of elections here and there. But they could not reject it. So Ambedkar said, yes, I am here on behalf of the depressed classes with 2 mandates. One is to demand a responsible government. But he said, I have another mandate. And that is, we demand a representative government. He is the only person to have demanded that India must have a representative government. And that demand has been buried in the last 7 decades. And the quality of responsible government has been thoroughly undermined. Now, in these demands, you must read this document, this memorandum. And there, as I said, there are 8 conditions. Condition number 4 is adequate representation in the legislature. That's where he says a demand. He did not ask for a communal electorate. He never used those words. That was used to denigrate his demand. He said, for 10 years, the depressed classes must be able to select, must have separate electorates to select their own representatives for 10 years, after which he said, you can have reservation and joint electorates. So that their own leadership will develop. He did not say, as our very revered Mahatma Gandhi said, I am the representative of all Indians. Muslims, Harijans, everyone, I am the representative. Ambedkar did not say, I am the representative. He said, you have invited me here. I'm conveying the request for the depressed classes, not that they should accept me as their leader, but they should have separate electorates to select their own leaders. Now, this demand was accepted by the British government. We had the Satyagraha, fast unto death, Pune Pact. We know all that. And that was rejected. Fortunately for us, we can assume that Gandhiji did not read beyond condition number 4 and come to condition number 5, which asked for adequate representation in the public services. And there he said, he drafted actually, in all of these, he drafted constitutional clauses to be included in the 1935 Act, because these roundtable conferences were intended to prepare the draft of have consultation on the draft of the 1935 Act. So he actually had constitutional language on each of this, not just a comment, very beautifully drafted constitutional provision. So this condition number 5 is the original draft of what later becomes 16.4. This is purely written by Ambedkar, not a result of a negotiated compromise in the Constituent Assembly. And what does he write there? He says, in essence, he says, but using his words, he first says that we have a problem. What is that problem? The problem is that the Hindu upper caste, his words, not mine, have monopolized public services in this country and are abusing this monopoly to benefit themselves and deny justice, equity, and good conscience. As a good lawyer, jurist, he uses these words to the depressed classes. And he says, what is the solution? Now, in parallel, he had also made a speech saying when the British leave India, power should be passed not to an aristocracy or an oligarchy. These are his words, but to the people of India. So he says there is an oligarchy that is running, monopolizing public services and monopolizing power in this country. We have to dismantle it. How do we dismantle it? He had a very specific proposal in this draft. He said that public service commissions must be set up in the Constitution. And the responsibility of the Public Service Commission must be to ensure due, his words, due and adequate representation of all communities. Due and adequate representation of all communities. Not classes, not castes, all communities. And how would they do it? By regulating recruitment into public services, his words, to ensure adequate, due and adequate, which means for small communities, it must be adequate. You can't just be proportional to the population. Some of the large communities may have to give up some of their share. Some of the small communities may have to be given an increased share so that they are meaningful voices. When he says communities, he's not referring just to castes. In today's terms, he would be referring to women, to LGBT, to any group that considers itself a community, must have due and adequate representation in the public services. Legislature is already dealt with, executive and judiciary. So he used the phrase regulating recruitment into public services. Is that affirmative action? He did not use the word reservation. How did the word reservation come? Where did it come from into 1604? It came from the practice of Maharashtra, Madras, Mysore, and Travancore, where because of the pressure of the better off groups, the ruling, either the colonial powers or the Rajas, gave some space to basically the middle castes. It was basically an anti-Brahmin or non-Brahmin movement, although ironically in Kerala, the Malayali memorial was on behalf of Nambudiri Brahmins, saying that the Tamil Brahmins and what they call the foreign Brahmins are not giving them adequate space. And they did get Nayars and Nambudiris, they got that space. So in that sense, it was the elite, ruling elites that called this reservation. But the depressed classes through Dr. Ambedkar never called it reservation. They called it regulation of recruitment into public services to ensure due and adequate representation of all communities in public services. That's what we're dealing with here, not affirmative action. Representative democracy. Representative democracy. That was what was mirrored on the August 27th, 1947 comment by Muniswamy Nagapal, reminding them that, look, we are here for a representative government. Have you ever heard of a Supreme Court judge after 72 years with the last name Yadav? There has never been a Supreme Court judge with the last name Yadav, to my knowledge. There's the largest Hindu community in Kerala is Irava. They've had judges and attorneys generals, advocate generals, and Irava has never become a judge of the Supreme Court in 72 years. And so on and so forth. If you apply Ambedkar's principle, not as a quota, but in a representative way, like the United States Supreme Court did when Justice Stephen Breyer stepped down. What did they say? They said, look, 12 to 13% of the population, am I right, is black, African American. They said, we have an African American male, Clarence Thomas, but we've never had an African American woman. Maybe 6-7% of the population, but very important, very vibrant, very wonderful group. In fact, I was reading somewhere that they are the group that produces the single largest extent of new businesses, small businesses, very dynamic group. So consensus emerged that they must have representation. And we must appoint an African American, a black woman, as the next Supreme Court judge. And they did that. They looked at several black women, very distinguished. They found a very, very distinguished, amazing, you must have watched the confirmation process on television, amazing woman. They appointed her as a judge. Why? Because representation is important for them. And today, and this has been the case since 2010, the US Supreme Court, just 9 judges. There is not a single member of the white Anglo-Saxon Protestant male community on that court. It is entirely a minority court. The single largest group are Catholics, who are the most hated minority. 150 years ago, the white Anglo-Saxon Protestants would have riots against Catholic, attack Catholic, churches and so on, right? So they have 100% non-dominant group Supreme Court. It's like having an Indian Supreme Court with no upper caste. 34 judges. Upper caste male, let's say. Now, if you look at it from the US Supreme Court point of view, or the British, UK Supreme Court point of view, European courts point of view, they're all these cutting edge, latest market economies are always monitoring representation because they understand, remember, taxation, no taxation without representation. At the heart of their idea of democracy is, we don't want to be ruled by others, we want representation, we want to rule ourselves. So if you look at all these cases, all these jurisdictions, you will find there is a central concern about representative democracy. And that is the demand that was raised by Ambedkar in 1930-31 and reiterated. And what we today call reservation is regulation of recruitment to public services to ensure due and adequate representation of all communities, not just castes. Okay. And this is, okay, now to come back to Carson and in that point, where does affirmative action come there? So the Americans and the French believing in elitism. Now I'm at the second point, longer point I made is to show we reject elitism. We want representation. They want representation, but they also want elitism. We don't want elitism. We want, because we know that elitism is not scientifically defined, that merit is defined by context, not by birth. And every human being is equally valuable, and you never know when your life will depend on a human being that you never considered meritorious or worthy. So the challenge for us in the rest of the world, us indigenous people all over the world, is to accept and deploy the infinite inherent potential of every human being, rather than to run them through a standardized test and trash those who don't come out through it. So we didn't accept that. But where does the word affirmative action come from? So the compromise Carson says that was reached is, okay, we have overthrown the aristocracy. We reject the idea that the proportion of more capable and less capable people is greater in the aristocratic classes than in the working class. We reject that. We all know that we find amazing people in all sections of society, not just amongst the high-born or the high-placed, right? So they recognize that. And they said, okay, our task is to find the meritorious, the elite, the superior people in all segments of society, working class, upper class, middle class, men, women, different races. Hidden amongst them are the meritorious. We have to find them. And then we have to develop them and make them part of a meritocracy, an elite meritocracy that must rule us. That consensus emerged, and affirmative action is a process of finding the meritorious amongst segments that were denied the opportunity to become part of the elite, the meritorious, and to make them meritorious and part of the elite. But building a new elite is not part of the aspirations of the freedom movement of India. As the Dalit members said to the Constituent Assembly, we may be dumb, we may be illiterate, but recognize our humanity and give us our due share. That is the philosophy behind us. Therefore, affirmative action has no place in India. No place in India. What we must talk about is the challenge of representation. Now, a second point. Now that what is reservation? That's a simpler point. Reservation is only a tool to achieve representation. And what Ambedkar wanted was regulation commensurate with representation, not a fixed quota. So if you have X community, if you've got out of 34 judges, 33 are Yadavs, then no need to reserve seats for Yadavs. In fact, you may have to reserve seats for Brahmins to give them, 1 or 2 seats. So you regulate, you modulate the extent of reservations as necessary, but to ensure representation. But you monitor representation. Today, we don't monitor representation at all. And we assume that 4 communities that dominate India, dominate all these segments, simply because they're meritorious. And so you don't monitor merit because you've already got standardized testing to filter merit. So anyone who's come through standardized testing is meritorious. A falsehood that has been rejected everywhere. And therefore, we understand that reservation is only a tool for representation. And if we can find a better tool, I said this to the Supreme Court directly, I said it in other places also, we will throw reservation into the Arabian Sea. We have no interest in reservation. In fact, reservation is an idea of the Savarnas. It is the heart of Chaturvarnya. This manual scavenging is reserved for you. This priestly job is reserved for me. There has never been a charter in the subcontinent by the British or the Maharajas or the Muslims that guarantee equality and equal opportunity to the common people of this country until 1950. And Ambedkar knew that this clause is in that charter of 1950 because of the struggle of the depressed classes. Because if it was reflective of the ideology and ideals and aspirations of the ruling classes, we would have had it in many charters before 1950. And so Ambedkar said no more than 50% reservation. Why? Because he knows I have to protect equality. Equality is here only because of my people. This is not from the upper caste. This is from us. This is our creation. We have to protect this baby. It's our baby. And reservation is a tool of Chaturvarnya that we should use. Not reservation, the regulation of recruitment, which was called reservation in 1604, should be used in order to get representation and end the abuse of power and the monopoly created by the dominant classes in the public services. So reservation, that's why no one has a problem with, I've never heard anyone say that putting a pole vaulter into a medical seat because he's good in pole vault will affect the merit of doctors. I don't see any logic for putting sports persons into medical colleges. But no one says that's going to destroy destroy merit in medical colleges. But if you put a scheduled caste or a Avarna into a medical seat, oh my God, what kind of doctors will we have? Because these are hopeless people with no capacity. But a pole vaulter, maybe he'll pole vault into the operating theater, one day to faster than the Dalit. And no one says women's reservation. I don't believe any of this affects merit because we don't understand merit. But no, I've not heard anyone criticize that women's reservation will destroy merit. Or giving reservation to children of central government employees to Kendriya Vidyalaya. I am a child of a central government employee who studied in a central school, but there was no reservation then. But no one said that because of me, merit was destroyed, right? And so on and so forth. So we understand that our problem is with this SC, ST, OBC, these avarnas getting, doing roles. You have no problem in giving manual scavengers 100% reservation from the communities condemned to do that. That will not affect the merit of manual scavenging. It won't be done properly unless a few Brahmins or a few Kshatriyas or Vaishyas do it. This manual scavenging will become a problem. So let's stop this 100% Valmikis in manual scavenging. I've never heard anyone say that. So we understand that this prejudice against reservation is purely casteist. And that's why we don't want to say reservation. We want to say affirmative action. Sounds very American, right? Not relevant to us. So reservation is only a tool. It's a tool of Chaturvarnya. We are using it as the most moderate tool available to get representation, 50%, because we want to protect our baby equality. Now, are there other tools? Yes, there are. What Mahathir Mohamad did in 70s and late 70s and 1980, when I was teaching, the dinosaurs used to roam in 1980 to 83, I was teaching law, the Faculty of Law, National University of Singapore. That was the time this policy was being implemented. Mahathir Mohamad put in a policy called Bhumiputra policy. And he said in Malaysia, no one, and there the oligarchy was Chinese, the economic oligarchy, and the Malays were very poor. So he didn't bother about 50% reservation in sweeper jobs will make the Malays better off. He brought in a law, Bhumiputra law. What did he say? He said no company can be established in Malaysia, no firm can be established in Malaysia unless a Malay, a Bhumiputra, is an equal partner and equity partner in the business. Even if he does not contribute a paisa of money or any other kind of capital, you cannot start a business without a Bhumiputra partner. And where are we? Almost half a century later, the Malays are better off, Malaysia is better off, Chinese are also fine, but Malaysia has been transformed. Now, if you don't like reservation, we can have the equivalent of the Bhumiputra policy, that you cannot start a business here in this country without having a SC, ST person as a partner, mandatorily, equity partner who will share in that. And there are other options like this in other countries. So what Ambedkar suggested through regulation of recruitment to public enterprises was the most moderate option. And this is only a tool. So the fight is not for reservation, it is for representation. And the question we have to ask is, do we have a representative democracy in this, a representative state in this country? No, we have an oligarchy of 4 communities at the national level, 2 communities in my state in Kerala, and every other state has 1 or 2 or 3 communities. And bulk of the positions belong to them. For example, in Kerala, there has never been a Malayali Muslim chief secretary in Kerala. One UP Muslim IAS officer became a chief secretary for a little while, from 1956 till today. There has been only one police chief who is Muslim for 25 days, from 1956 till today. And other backward classes and communities, similarly, 1 or 2. The rest are all from these oligarchic Malayali communities. So I can give you examples, a lot of data to show that we are highly oligarchic as a country. Now, there's a lot of study. There's an MIT professor who's written a book on oligarchy, because he says that if you have an oligarchy, a country will never move forward, will be destroyed. Why? Because all the policies of the state will be geared to ensure that the oligarchy's goals are met and the oligarchy is sustained. The rest can go fly a kite, but that's all that the state does. So you cannot really, no country can develop with an oligarchy. Now, what Ambedkar said, please remember, is oligarchy should be stopped on behalf of any community. He didn't say there should be a Dalit oligarchy or an OBC oligarchy. So the vaccination against an oligarchy is to have a state and all other sectors where there is representation from all communities. That's the medicine against oligarchy. That's what we are talking about. Now we come to the issue, having dealt with the concept of affirmative action and dealt with the concept of reservation. We come to EWS. EWS is supposed to be reservation for economically weaker sections. So I filed a case in the High Court with Kerala, which they've refused to. They will neither admit nor reject nor hear. And I made a simple proposition: if this is for economically weaker sections, you give it to people based on their poverty, just income. Look at their BPL card and nothing else. Give it to the poorest people. But what do we find EWS as? EWS basically is for socially and educationally forward classes. What does that mean? Now, we all know that there are socially and educationally backward classes who are upper caste. Can anyone give me an example of a person from an Savarna, upper Savarna Dvija background who is a member of a backward class? Apurva, can you think of someone? Have you heard the name Narendra Modi? We know he's an OBC, and his community is a Bania community by all accounts. But they're backward class. Manipuri Brahmins, backward class. Kerala, Velakathala Nayars, backward class. Now, Mr. Modi's community, both Ganji community, I understand based on is a genuinely backward class. They may be Bania, Vaishya, but they do the oil pressing thing, and many of them are not, they don't have representation, they don't have voice, they don't have. So some years ago, before he became Prime Minister, they were made a backward class. And it's correct. Manipuri Brahmins, many other upper castes are in the backward classes. Have you ever heard SC, ST or backward class, Avarna backward class protesting that these upper caste communities are being made OBC and given a share of reservations? Never. So let's first understand that EWS is not for all upper castes. It is not for the upper castes that are backward, socially and educationally backward. It is only for the upper castes that are socially and educationally forward classes. The creme de la creme. And therefore, the creamy layer cutoff has to be very high, 66,666 rupees or less income per month, 5 acres of rural land and so on. Because otherwise you're talking of creme de la creme. You have excluded the socially and educationally backward classes amongst the upper castes. And so you got to put this thing very high. Now these guys are so powerful that they can make, not only these guys are getting one job or one educational seat, but they have come from communities that are so powerful that they can make a whole college for each of these guys. Talking of other means available, not to the state, but to these communities. But why are they doing this? Because they want to take away 10% reservations from the backward classes. Not because they need it, because they want to take away 10%. 10% is massive. And these MDPI indices show that there can never be 10% of the population of India which is poor amongst the social and educationally forward classes. Yes, upper caste, there are many upper caste poor. 2 days ago, I had a young boy drive me, I gave my car in for servicing, and he dropped me back. And he comes from an upper caste Nair background. He said his father was a wage laborer. So there are poor amongst them. But if they are not getting reservation, their community can apply and become backward classes and get reservation. No need to create EWS. And many have done so. If anyone has been left out, they're free to do so. Then why EWS? Because you want to take away, you want to cut down reservation for those who are excluded. That's why I said, I'm not here to argue against the exclusion. In fact, the main point I made was I didn't cite this, but it's based on, some of you will recognize this, John Rawls' difference principle, where he says that you can discriminate against someone, you can treat someone unequally for only one and only one reason, for the benefit of the least advantaged or the most disadvantaged. So I said to the court, I said, I'm not here to argue against exclusion, because I told my friends, look, you lose that. But I'm here to argue against the inclusion. I said, on what constitutional principle can you violate equality in the Constitution to discriminate in favor of the most powerful? And on the fifth day of argument, that it was not live streamed, Chief Justice Lalit, sitting in open court, reflected on this. And he said to the open court, from the bench, remarks from the bench, he said, all these years, he said, it's almost exactly verbatim, but I can't swear it is verbatim. He said, all these years we've been used to having upper classes, he didn't use the word caste, upper classes discriminated against in favor of the less advantaged people. But he said, this is the first time that we are going to discriminate against the least advantaged in favor of the most advantaged. And he said, that is the real issue in this case, he said. But neither the dissent nor the majority judgment dealt with this central issue. And I would submit that this strict scrutiny standard, which is applicable to test the constitutionality of statutes, right, which allege discrimination, and then you test them against the test of compelling interest and narrow tailoring, is not relevant to reviewing the constitutionality of an amendment to the Constitution. America doesn't deal with that problem. It's an exercise of constituent power. It can be tested only on the basis of violation of basic structure. So we basically argued that it's a violation of I argued two principles of the basic structure. One is representative democracy and the other is equality. Equality not by the exclusion, but by the inclusion. Because you have the equality, its very essence of equality of the Constitution is you will not discriminate in favor of the privileged and the powerful. We are back to Chaturvarnya if you do that. And so this argument is not dealt with by either case, and I put that in the review petition. One reason I frankly did not appear in the morning here was we have a review petition, and that's before Justice Butt, so I didn't want to be around Justice Butt, who I love very much and respect very much in all ways. He's an exceptional human being and a judge and a jurist. But this is the real issue. This is where a Rubicon has been crossed. This is why I told the bench that this is the ADM Jabalpur of social justice. Because you're writing into the Constitution that it is legitimate to discriminate in favor of the powerful. Next, we can have reservation only for men. Poor men. Poor meanings, not economically poor, but bichara, men. So EWS is really not economically weaker section reservation. Is that really 610 or? Okay. I'm almost done, but sorry. It is not a really economically weaker section reservation. It is reservation for the socially and educationally forward classes with a creamy layer cutoff. Exclusively for socially and educationally forward classes. I have an actual case. I'm talking to them, not case file, but actual problem in Kerala. There is a Kumbhara community in Kerala, and one subset amongst them, extremely poor community. One subset amongst them, relevant to say here in Hyderabad, are people who some centuries ago, they don't know when, migrated from Telugu-speaking regions to Kerala. And they speak a language which has kind of a mixed Telugu, Malayalam kind of thing. And the people in Kerala are afraid of them because they talk these strange languages and they have some strange customs, quote unquote, strange customs and rituals. They're very different. They are part of 89 communities that are given 3% reservation. And they have never get reservation. And they're extremely poor. In Kerala, the Nambudiri, who doesn't get this 66,000 or whatever the number in Kerala is, and 5 acres or whatever the number in Kerala is, below the creamy layer, is eligible for reservations under EWS, but this Kumbhara is not. For a reservation that's called economically weaker section reservation, adding insult to injury. Why don't you amend the constitution and say, we want to give reservations for social and educationally forward classes with a creamy layer cutoff? Have the guts to do that. Have the honesty to do that. Don't smuggle this into a reservation called reservation for economically weaker sections while you're denying these poor Kumbharas reservation, giving it to the Nambudiri and the Nambiar and so on and so forth. I have nothing against these communities. They're all wonderful communities. I'm just saying they happen to be social and educationally forward classes. I have a lot of respect and admiration for them. But even they would not feel comfortable if they knew that they were snatching a seat away from these Kumbharas and others who are not getting reservation. So what I'm arguing is the words other than, EWS is for other than 15, those who are the classes mentioned in 15.4.16.4 must be interpreted as other than the people who actually receive reservations under 15.4.16.4. Not simply that you are born into a community which, not at your application or request, is classified by the state as belonging to a particular, into a family that is then classified as belonging to a particular community, and the state decides that community is eligible for OBC, ST like Kumbhara, and therefore you are not eligible for EWS. If you are eligible to pension, you are not a pensioner. You become a pensioner when you receive pension. Similarly, you are eligible for 15.4.16.4, but you should be excluded from EWS only if you actually receive. You have not excluded people who receive women's reservations, sportsmen reservations, domiciliary reservations, children of reservations. None of them are excluded from EWS. You can be eligible for a multiple set of reservations and still get EWS. But if one of them is OBC, SC, reservation, you're knocked out. This is not right. Either say you should be, there's almost no one like that, you should not be eligible to any kind of reservation. But you can't single out just SC, and OBC reservation and say that knocks off your eligibility. So we can interpret it to say other than means those who may be eligible, but take the Kumbharas. They're eligible but don't receive it. So don't knock the Kumbharas out. And you include them in EWS and make the EWS genuinely EWS. Give it only on the basis of multidimensional poverty index and nothing else. Do not require that this must be you must be a member of a socially and educationally forward class to get EWS. So now in Kerala, I call EWS enemy of the weaker section. That's the right way to understand it. It's not economically weaker section, it's enemy of the weaker section. Because it's taking away, depriving weaker sections, whether even of the upper castes and of the others, it's depriving the genuinely economic weaker sections from representation, not from jobs or poverty, from representation, from having their voice in the legislature and the judiciary. Now that's unforgivable. So therefore, we have to rethink affirmative action, we have to rethink reservation, replace it with representation, and see it only as a tool. And the tool is regulation of recruitment into public services. And we must also rethink the exclusion. And I do think that exclusion of people, see, obviously you can only get one type of reservation. So once you get reservation, you're automatically under another category or excluded. No need to say that. But at least now, if you want to keep it, rethink the exclusion. Lastly, I want to say that we should hopefully we should be aware of the fact that there is a review petition, and these arguments still need to be made. The arguments that were not addressed by the judgments need to be addressed, and we will do so. So we won't take it as a done deal till the review petition is rejected or dismissed. But I do want to say, in conclusion, that there is immense value in simply standing up and speaking for ourselves without worrying about whether we win or lose cases. I'm very liberated from all this. If I lose cases, all the cases I argue, I still don't lose any clients, because I have no revenue from clients, and I don't lose clients because the clients have no option, to get someone free to argue for them, either it's me or no one, and so I don't have to win cases to remain in the practice of law, but I do. So with that acceptance, I would say that the value I see is that when you make an argument, people, people are all, as Nagappa and Muniswami Pillai said, everyone is an equally intelligent human being. And if you make an argument that's reasonable to them, like I do, I've made these arguments to all kinds of audiences. They fully understand what you're saying. And when you can make it in a court and it gets publicity, then it gets shared, then there will be greater public awareness, and that can be a very important contribution. So I would encourage all of you to be critical about judgments, critical about laws, critical about what goes on in society, and to use your professional license to make the best arguments you can in the interest of the most marginalized people. And then I think this evening would be well spent. Thank you so much.
Five minutes, 15 minutes. Wonderful. So I'm going to throw the floor open for questions. May I request that the mic, if anyone feels confident they don't need a mic, just start speaking. Go for it.
Executives dealing with inequality has been decreased. Firstly, Dr. Shankaran, should something like, let's say, budgetary allocations be scrutinized by the judiciary, for it seems to be a policy matter? Secondly, Dr. Alam, considering that what Dr. Shankaran suggested to be the case, how non-judicial forces, or if I may, political or politically partisan forces, tackle this with the intent of bringing back accountability in dealing with inequality? Lastly, Dr. Gopal, in our previous panel, we discussed how rising populism, which is majoritarian in its nature, in the South Asian nations challenges constitutionalism. How in such a society we create this consensus required for having the representation of all communities you were arguing in favor of? Thank you.
If it's okay with the panel, we'll collect some questions and come back to you. Okay.
Professor Gopal, this is a question that I've asked you before, but since we have a room full of law students and I want you to talk about this, as a constitutional lawyer, when you see the courts are not deciding on first principles, when basic issues don't get addressed in judgments, and you lose case after case in high stakes matters like this, why do we go to courts? What do we make of the judicial system in that context?
Thank you so much. My question is addressed to Doctors Kamala Shankaran and Dr. G. Mohan Gopal, and it's related to the last question, actually. You'd mentioned that the court in Ashoka Kumar Thakur precluded the use of the strict scrutiny standard. But in general, I think that in most of these judgments, the decisions are based not on a lack of judicial tools, but like Dr. Mohan Gopal did point out, the constitution of these institutions. For example, in the Supreme Court, there's an overwhelming Brahmin hegemony. So how do you think we address the structural questions of applying constitutional first principles and ensure that courts actually engage with the issues that need to be engaged with? Thank you.
Thank you. Most of the questions which came sort of did cover a lot of different themes which I also wanted to ask in my questions, but I just had one directed sort of theme which I wanted to also ask a question to the entire panel. With respect to the issue of like Pasmanda Muslims in India, there is obviously the question which of mine comes from this perspective that there is a very huge communal sort of divide which is going on in our country today. So how can we sort of reconcile the idea that if caste is a corporeal experience which goes across different religions, different minority religions also have the issue of caste in it. And if the state has to take steps to sort of bridge the gap and provide opportunity and representation, how can the issue of Pasmanda Muslims, because of the fact that they aren't even given identity or they're not even recognized in a way that they are being oppressed because of their caste identity. So how can that be reconciled in today's time? Thank you.
Hi, my question is for Dr. Shankaran. So it was like you stated that in MR Balaji, no, sorry, I'm sorry, in Ashok Kumar Thakur, we said we asked not if we should have reservation, if we should have affirmative action, but how we should do it. And you said that even in this case, even in the EWS reservation, we should not question if we should have it or why we should have it, instead how we should do it. But since the phraseology of the amendment clearly states that it's in apart from the classes mentioned in our subclause 4 and 5, don't you think it boils down to a question of why we should have it? I think like it's a question of whether it should be there.
No further questions? Over to the panel.
Yeah, I want to make sure that you have enough time. No, please start kindly, if you don't mind.
Yeah, okay, I'll be very quick. Okay, so this question about whether there should be judicial, firstly, thanks for all the questions. Okay, should there be judicial scrutiny over budgetary allocation? Now, I know that there is separation of powers. The point I was trying to make is that, and I'm going to club the first two together. I did make the point that normally for constitutional amendments, we go for this higher level test. But by not requiring a law to be there in place, there is no occasion then for the court to ever apply the normal test for constitutionality of a law. You're dealing directly with executive action. And when you deal with executive action, which flows from an amendment, my suggestion is that that question which never gets asked, could there have been a better way to deal with it than this reservation itself? That is never addressed by the court. So speaking very clearly on what the executive does, we normally have a judicial review at the margins, not on merits, but whether it violates a broader structural issue of division. I accept that. But when you say that this is the way that we're going to address economically disadvantaged people, you're compelled to ask what would have been otherwise rejected as a strict scrutiny question in a constitutional amendment case. Okay, you're compelled to ask that. Whereas when the only question that you can ask is with an identity, it doesn't change the identity. But you cannot ask, was there any other option available? You have to defer to there's judicial deference to parliamentary, but that's the question that I was asking. And if strict scrutiny is not a tool, how would courts deal with structural matters such as this? Somebody there asked this question. Yes, it is a structural question, but when you look at judicial oversight, the fact that Part 3 has so many methods by which the Indian government can address inequality, why one was chosen and not the other is a question that is normally not raised before the court. So I'm suggesting that these also should be questions that get asked. Is it interfering with the role of the executive? My answer is that the executive also has a toolkit and an area of influence that it has. But which choice, which one, somebody must also check that. Is it only a political question that will be settled by the electorate, or can there be not? So since this is new ground, I really cannot elaborate it further, but I think that this is something we should consider. On the question of the Pasmanda, I'm going to leave it to Dr. Afroz to discuss. And on that last question of if but not how of the amendment, okay, I was speaking at a meta level that when you have affirmative action reservation in a constitutional scheme, the whether you need to have that in your toolkit has been taken off the table. Okay. This, of course, is what type of, so again, it comes down to a more micro matter rather than a macro matter. So if we want to quibble with words, well, if and when, but not the big, big if. Okay.
Right, because I personally feel that if the panelists are not being questioned, then nothing is being done in the session. All right, the question is that how political forces should come out with new ways to bring equality. That was and accountability. All right. So the point is, everybody is talking about that the government, the politicians should do something to bring the account they should be accountable. The point is that if you are not having a conscious citizenry who are there to raise questions whenever the state become deviant in their lives. The first thing is that you need to create a political culture where the citizens are being trained in raising questions on what the governments are doing and why some policies are being made. So in the absence of conscious citizenry, no government can be accountable. No policies can be critiqued. The idea is that the governments by nature are not in mood to be accountable or responsible. It is we civil society, it is people, it is we, the people should work as an opposition to them. So the second way is to have transparency. And we should demand transparency. Until and unless the data are not being given before us, we cannot make an informed decisions. So whether that, what is the purpose? Unless you are not having a data. I am not having a data that which caste or groups or communities are doing in their respective sectors with having a caste census. No. I cannot say that reservation is wrong, whether it has achieved or not. I cannot say that. Why can't you include all those things in the NSSO yardstick that include that what the communities are doing? So what we have achieved. So let us tell the people that, see, we have done this much. These are the things are yet to be achieved, and therefore we are making up the further policy. So we must have a transparent government, but that transparent government will not be an idea if we are not having a conscious citizenry who will demand for transparency. So the responsibility lies on both, not only the state to be accountable, but also the people. The second point was that the Pasmanda Muslims. All right. So the Pasmandas, we have generally being understood that there is a Muslim community. The moment somebody raising a questions that there is a Pasmanda, oh, you are compromising with the integrity of the whole idea of being a monolith Muslim. So the point is fine. The whole idea of Pasmanda is that reaffirming the fact that there are social questions in the Muslims as well. There are gender questions, there are economic questions that need to be addressed. And one of the social question is a Pasmanda question, which is equally at a parallel structure like the Varna system we are experiencing in Hindu society. That there is an Ashraf like higher caste, there is an Ajlaf like OBCs, there is an Ajlaf that is a Dalit structure is there. The Pasmanda activists are talking about the rights and dignity of those Muslims who have otherwise experienced discriminations historically within the larger Muslim scheme or population in India. They face social, economic, and political exclusion on the basis of their caste background. So the point is that when we talk about the caste Dalits, should that Dalit be a category exclusively for Hindu society? No, Dalit is a Dalit across the religion, across the groups and communities. Similarly, that we need to, what is the point is that we need to acknowledge first. We need to recognize first that there is an entity who are experiencing specific challenges and they need to be integrated into the entire scheme. The question is of inclusion. Are they included in the overall schemes of the government? No, that the entire Muslim should be recognized as a backward classes. This is a wrong proposition. I think that the entire Hindu society should be recognized as a backward classes. No, there are specific reasons. Similarly, that we need that there must be certain initiatives to promote them, to empower them educationally, economically, in the healthcare, in the representation. Because that each religion, because when there is a question of representation, this question is not limited with the yardstick of religion alone, that it goes along various cross-cutting lines of the identity concern. And that is what we are talking about, differentiated experiences of the different community. But who are getting benefit in the name of Muslims? My forthcoming book is all about in the name of Muslims, that who are the beneficiaries of the Muslim politics in India. Are there, because if I say that, there are certain universities in India who are exclusively run by the minorities. In that minority institution, if I compare that, who are the vice chancellors? If I find that none of the vice chancellor are from the Pasmanda Muslims, what should I say that? The Muslim means the Ashraf? So the point is that in the name of Muslims, who are getting the benefit? So that needs to be probed and questions. We need to engage these questions, not because that we like or dislike anybody. We have certain responsibilities being as a citizen of India, and every community, every identity should be adequately represented. That what Ambedkar raised that. So that is, and he was the first one who was raising the question of Pasmanda Muslim. If you will read his book, that Pakistan or Partition of India, you will clearly identify that he was a clear perception. My whole worry is that why Muslim community failed to produce a leader like Ambedkar. So you have a leader that who's talking about the community, that each communities that is irrespective of their social locations, that empowerment is being talked of. So this is what about that. It's all about a question of bringing rights and dignity of those groups who are otherwise being historically discriminated by virtue of being a member of a particular caste groups. Thank you. Hope I made some sense.
Yes. Oh, okay. Yeah, this would work. Okay. So one couple of questions which remain. Populism versus representation. I think they're two different things. Populism is basically a policy of appealing to people based on their demands, to cater to them. Representation is the opposite. Because when you cater to them in populism, some higher authority is giving them what they want. That's populism. We will give you what you want. Representation destroys populism because people have power themselves. And they will take what they want. They're part of the power structure. So populism, we have populism because we have an oligarchy. And the oligarchy needs their vote in a democracy, which is not representative. And therefore they want to get their vote through populism. But in a representative democracy, there will be no need for that. That's my very quick response to what you're saying. I think what we need in this country is refocus almost 100 years later on the centrality of Dr. Ambedkar's demand for representative government and a representative society and a representative polity. in our country. That will solve, because we are such a diverse country, representative approaches will ensure there is less conflict, more voice, more consensus, and we can move forward. In fact, I would argue that the great sort of difference that emerged in the West compared to the rest at a critical point of time was their embracing of the idea of representation and demanding representation and getting it, even against their own church, for example. There are many Christian churches where the priests are elected by the congregation. So they move towards everyone has to be represented. 87% of judges in the United States are elected in elections. The jury is selected randomly. They make decisions. So this idea that participation and representation in power is essential for development and stability of a society is very important. After 1947, when there were three powerful groups in the country, a dominant Hindu group, a dominant Muslim ruler group, and the British colonialists, two disappeared in 1947. And after that, we have a problem, because we have only 4 or 5 communities, dominant communities, that are powerful. And no other community has the power to challenge them. And that's not good for society. There are two options. One is, because the problem is that there is inequality of power between communities. And the two options are, one, make everyone weak, that's very destructive, or the other is make everyone strong. And then you'll have countervailing influences and a social balance. The dominant communities will always say this is a prescription for anarchy. Only we should be powerful, because we will ensure that others are suppressed. But the experience of Europe and the experience of China tells us the opposite. Forget the Communist Party, but they overthrew their oligarchy, they overthrew their aristocracy, and common people started to occupy the governmental structures all across the country. The country moved forward. Compare Kerala with other parts of the north of the country, where there is more representation and more participation, and you see the social indicators. So the evidence is overwhelming that representation will produce not anarchy, but real sustainable progress and move forward. So we should, the young generation, should demand our transition at whatever cost, on a deontological basis, as an end in itself, a move to representative democracy. That raises a very important question. Who is the unit? When Ambedkar uses the word community, not a caste, community, right? What is a caste? Who is a community? Who should be represented? And there the approach, I think, which we have seen historically is communities are formed in a very organic way. We have communities today that did not exist 100 years ago, will not exist 100 years from now. So you take this as a organic social process. And whenever there is a critical mass of a group of people who have come together and identify us, a denomination, it's a very wonderful word, like religious denomination. You're removing your name. Denomination. Nomination to an assembly, giving your name. Denomination means I'm now part of this group. Now 20 of us say we are denominating from the rest of you and we are becoming a separate group. Then we must have representation. We must have representation. So rather than decide who will have representation, look at the empirical reality and see who are the people that have denominated and make sure they have voice, which is adequate and representative in proportion to their population. So this is a broad approach that Ambedkar gave great importance to, but has been forgotten. So that makes populism actually quite redundant. Why do we go to court? I think I'll reply with a story. There's an actual story of a guy who was in Austria, and he was single-handedly fighting the Nazis. So someone asked him, why are you doing this? They're going to come after you. A little bit, I have that feeling now they're going to come after me, but and I think of the story. So his reply was, you take a bee, the insect bee, you put it in your palm and crush it. It will bite you. It will die, but it will bite you. Because its responsibility is to stand up for itself. So we go to court because we have to stand up for ourselves. That's our responsibility. We may not be able to do it in Parliament or in the executive. The courts are the only place left. So there was no debate on EWS in Parliament. But we were able to get the Union of India to come before us and give us their justification for EWS only in a court of law. We could not do it in Parliament. We could not do it in the executive. So we must file cases, very good quality cases with excellent pleadings. That's where we have a responsibility. And I said this a couple of times in other places, but I do want to say in this group that the battle for the survival of this glorious republic we have, 1950 republic, is being fought in our courts, not in Parliament, not in the executive branch, in our courts. And we can all play a role in making sure that the best arguments in the defense of the republic are placed before the courts. And those arguments may be rejected, but there is power even in the rejection of those arguments. People will be outraged. How could you reject this argument? You saw how when the 3-2 majority split, that was a reaction of people. How could your arguments have not been accepted, right? So we want to create that. So we must go to court. We must argue. We must stand up for ourselves. And what to do to get the courts to engage with us? Courts must be representative. Imagine if the United States Supreme Court had 9 old, white, Anglo-Saxon, Protestant males only. Would they deal with the same set of issues in the same manner that they are now dealing with? Now imagine, not as a quarter, roughly speaking, if you look at this due and adequate representation by Ambedkar principle, 8 judges of the Supreme Court out of 34 should be SC/ST. 50% of all this should be women, or at least, but 8 should be SC/ST, men and women. 5 should be Muslim. Roughly 20 should be Avarna, OBC. Maybe 1 should be Savarna, forward class. Now imagine the jurisprudence that would come from such a court. Now many of them are women, many of them are LGBT, many of them are representing different approaches, different ideologies. What a beautiful court it would be, right? In terms of what issues they would take up, what jurisprudence they would produce. So I think the courts are just a bunch of people. The issue is not what do courts deal with. The question is, who are the people sitting there and what are they engaging with? It's like Sandra Sotomayor almost lost her nomination because 4 times she made a speech saying that as a Puerto Rican Hispanic woman from a poor background, I will make a better judge than a white man because I have the experience that they don't. And she was right. And they advised her to retract that and say, well, maybe as good, but not better than. She said, no, better than a white male. So it matters, who is sitting in that court, and it will change what the court engages with. I want to make 2 quick points on, just because it's a set of students on constitutional law, that I feel that, we see in no approach to judicial review, including the 3 standards of rational basis, intermediate scrutiny, and strict scrutiny, will a judiciary ever step into the shoes of the legislature and say, this would have been a better policy? That's not part of judicial review. Judicial review in rational basis, the simplest, which applies to all legislation, is simply to see whether there was a rational basis, whether there was a legitimate state interest, and whether there was what we call a rational nexus test in the Wensbury principles, whether there's a relationship between goals and means. And the intermediate scrutiny test applies to these situations where the allegation is no equal protection. So you go beyond that and examine that equal protection clause more closely. Was a fundamental right violated, and was a fundamental right violated of a suspect class, like race or gender and so on? You examine that, and then you strike that down as illegal. You cannot actually replace the policy choice of the legislature. You can either say this is legal or it's illegal, but you cannot step into the shoes of the legislature to examine alternatives. And strict scrutiny applies to others also, but mainly when the law is alleged to discriminate. And then you look not only when it seems that the law does discriminate, then you see, is there a justification for that discrimination in terms of compelling straight interest and narrow tailoring, right? So I think the options available to a court in judicial review are actually very clear and very limited of saying, is this permitted? There is discrimination, there is lack of equal protection, there is some other challenge to legality. Are those challenges valid or not? If they are valid, then strike them down. But we do not want a situation where the court is now trying to say that we will decide what is the best way to deal with the problem of poverty or backwardness and so on and so forth. So I think we should maintain that clarity of distinction with due respect and not in disagreement, but just to make that clear. And I've already dealt with this issue of, from a legal point of view, we need to have much more clarity on what is a community from a legal point of view, constitutional law point of view. Who constitutes a committee? And my fundamental point is this cannot be a state recognized or nominated process. It has to be a bottom-up social process where the state recognizes, does not create, but recognizes the existence of social groups based on some objective criteria. So for representation, we need to build a whole new jurisprudence on what is meant by all communities, who is a community, and how should they be represented. Because I want to say that all communities includes the dominant classes and the dominant castes. They should also have representation. I've been saying that when the day comes when they do not have representation, even one seat on the Supreme Court, we should stand up and defend them, say they should have representation in the Supreme Court. So it's a principle that will protect all of us, and that's what we should pursue. I'm very happy that Justice Butt's judgment recognized that Article 16 can only be on the basis of representation. That was very important. Whether Article 15 can be on the basis of other than representation, I would apply John Rawls' deference principle and say even Article 15 discrimination cannot be except to favor those who are least advantaged or are most disadvantaged. Thank you very much. Thank you very much.
One clarification, Professor Gopal. I know you're running late. When the court examines and asks for justification, it's not going to choose which is the better alternative, but it compels the government to explain why other avenues were not pursued, and it has to go in for affirmative action.
That's where I feel that can only be in terms of showing a compelling government interest, the existence of a compelling government interest. But not to show there were other alternatives, but we are compelled to discriminate because there is no other option. But not to say that, look, there are other options and we have to, the court cannot examine other options.
It doesn't examine, but it puts pressure on the government to explain that they were compelled to do this.
That happened. That happened here. We did go into the question of, it was argued by the various council, you give them financial assistance, you give them scholarships, don't give them reservation. And the government said, no, these are people who are not getting admission and jobs. And so we are compelled to give them because they don't have the protection that others do. That was factually not true, but as I said, in the way they stated it. But I agree that this issue can be approached in this manner of letting the government explain why it was a compelling interest. That is necessary. It was done, but not convincingly.
Just one last 40-second thank you. On behalf of the Law and Other Things blog, the Azim Premji University and Nalsar University, I extend our warmest gratitude to all the speakers. You've given us an extremely edifying educational conversation. It was a consummate class on constitutional law, if you ask me. And it's addressing the central question of the Republic today. So thank you very, very much. You've allowed us to mine your years of prolific thinking, and you've helped us make sense of the times. I'm so grateful to have you all be with us in person today. Thank you so much, Professor Gopal, Professor Alam, and Professor Shankaran.